safe during these crazy times. It's great for us as a board to be back, and it's nice to see citizens and staff again. Please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Agendas of today's meeting are on the back wall at the entrance to chambers. Please remember to turn off and silence all cell phones. The Municipal Code Board consists of 7 members who are appointed by City Council. We serve voluntarily. It is this board's intention to promote, protect, and improve the health, safety, and welfare of the citizens of Clearwater by providing this equitable, effective, and inexpensive method of enforcing certain codes within the city. The board considers new business items in 2 parts. First, the violation, and then affirmative relief. Former rules of evidence do not apply. Each side is limited to 15 minutes. The board may grant additional time as needed. All proceedings will be conducted in a calm, civil manner. Individuals who conduct themselves otherwise will be asked to leave. If necessary, they will be escorted from chambers. Now I'll ask all of you who plan to speak to please rise and be sworn in by the clerk.
Do you swear or affirm to tell the truth throughout your entire testimony?
Thank you. Our first order of business is to review and approve the minutes of last month's meeting. May I have a motion to approve the minutes?
I'll make a motion to approve the minutes.
I second.
Motion approved, seconded. Minutes are approved. All in favor?
Aye.
Minutes are approved. Is there anyone here to speak to items not on the agenda? Very easy. Move on to new business. First order of business, case number 4.3, continued from 3/25/20.
Chair.
Yes.
Election of officers.
Oh, okay.
Yeah, 4.1 is
Gotcha.
election of officers.
Perfect.
Typically, we do this once a year in January, but here we are today. Mr. Menino is the senior member of the board, and Ms. Fuller, who's not here today, is the second senior member. Can I recommend? So I recommend somebody make a motion for Mr. Menino as chair and Ms. Fuller as vice chair. Well, 2 motions, right?
I'll make that motion.
Okay. I'll second it. Yes. All in favor?
All in favor?
Aye.
Aye.
Okay. So you are now officially the chair.
Thank you. Moving on. 4.3, continued from 3/25/20, 4/22/20, 6/24/20, and 7/22/20. Case 7920. Find respondents Onale and Chander Kapasi at 629 Bayway Boulevard, 302, in violation of code for residential rental business tax receipt and short-term rental, and issue an order with compliance deadline and fine if compliance is not met. Is anybody here to speak to that case?
This is a declaration.
Beautiful.
Congratulations. I will not be presenting. Welcome board. My name is Julie Phillips. I'm the inspection specialist for the city. Nice to have you. I will not need to present. They were once in violation, but they corrected it prior to the hearing.
Beautiful. So we will need a motion of declaration.
There should be a motion in front of you.
I move to find the respondent was in violation of the code as referred to the affidavit. In this case, the violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats a violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Perfect.
I'll second the motion.
Motion made, seconded. All in favor, aye.
Aye.
Approved, nay. Motion passes. Moving on, 4.4, continued from 3/25/20, 4/22/20, 6/24/20, and 7/22/20. Case number 81-20. Find respondents East Gateway Holdings LLC at 1390 Gulf to Bay Boulevard in violation of code for business tax receipt required and signage without permits. Issue an order with the compliance deadline and fine if compliance is not met. Is anybody here to speak to that case? No? Okay, we will need a first motion, please, board.
Before you do that, Chairman, the business did come and get their business tax receipt, so the city has withdrawn that violation from this case, so we that won't be part of this case, just the signage without permits.
Okay, so we're going to ask for a first motion on violation of code for business tax receipt only.
No, the opposite.
Signage.
Just for signage.
Just for the signage.
Yes.
So if anyone wants that, can make a first motion and just regarding the signage in case number 4.4.
I'll make a motion. I move that the find respondent in violation of the code as referred to in the affidavit in this case.
Does he need to specify?
No, because they've acknowledged that it was withdrawn, so it's just.
Okay,
a-
motion is made, seconded, all in favor, aye.
Aye.
Opposed, nay. Motion passes.
Hello, Board. Danny Knight, sign inspector for the city. This is case 81-20 for 1390 Gulf to Bay Boulevard for signage erected without permits. The city is asking compliance on or before January 18th of 2021, or a fine of $100 per day that the violation exists. We are asking the Board to authorize the following. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city's attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedy allowed under the law. Compliance can be met for signage erected without permits by applying for and obtaining a sign permit to allow the sign to remain erected at the property. Compliance can also be met by removing the unpermitted sign and refraining from re-erecting any permanent signage at the property until a sign permit is obtained. And here are just some snippets. This is a photo of from 11/13 of 2020 to show this is our database. There have only been 2 sign permits pulled at this location. One was back in 2008. Nothing current. This was on 11/6 for Solar Tech. This was the sign that's erected without permits. This was on 2/18 after the compliance date. And this was on 11/17. Any questions for me?
No questions from the board. Anybody have any comments or questions needed from city?
No questions.
So do you want to give your recommendation again, Daniel? Make sure I understand.
Sure. We are asking compliance on or before January 18th of 2020, or a fine of $100 per day that the violation exists.
And I assume you meant 2021?
I'm sorry, 2021, yes, sir.
If we can have a first from the board?
I'll make that motion.
I'll second.
He's going to make it.
Do you have to read it?
Go ahead.
You have to read it?
I move that we find the respondent in violation of the code as referred to in the affidavit in this case. Is that?
Okay, yeah, so we're doing the second one now.
I move that to enter an order requiring the respondent to correct violation on or before, you said January 18th?
Yes, sir.
Respondent does not comply by that date, the board may order a fine of $100 per day. Violation for each day. Each violation continues to exist. The fines and fees remain unpaid 3 months after such lien is filed. The city is authorized to foreclose, settle, collect, or settle such lien.
Do we have a second? A motion is made and seconded. All in favor, aye.
Aye.
Opposed? And motion passes. Thank you, Mr. Knight.
Thank you, Board.
Moving on to 4.7. Continued from 3/25/20 and 4/22/20, 6/24/20, and 7/22/20. Case number 8820, fine respondents Nili Yan at 900 Vine Avenue in violation of code for unsafe building, and issue an order with the compliance deadline and fine if compliance is not met. Is there anybody here to speak to this case? No? Nope. So we would need a first?
Yes. I would still like to show the
Yeah,
presentation, though.
Absolutely.
Let them
Oh,
go ahead and make the first
Yeah.
motion, and then you could show them.
I move to find the respondent in violation of the code as referred to the affidavit in this case.
I'll second that.
motion is made, seconded. All in favor, aye.
Aye.
Opposed, nay. Motion carries. Yes, sir.
Good afternoon, Board. My name is Jason Cantrell, Building Inspector for the City of Clearwater, and I'm presenting case 8820 for the property at 900 Vine Avenue. Here we have one violation of an unsafe structure, citing code section 3-1503B2 for a public nuisance. This was a fire, and this fire did occur back in January 24th, 2015. They were cited through a number of inspectors throughout the years. They did acknowledge that, and they did get permits and were working to repair the property. When I came aboard this department in 2018, I was directed to close that case and reopen a new one. So the remainder of the presentation is based on my case. So my notice of violation was sent 5/8/2019 with a compliance date 7 days from the receipt of the notice to secure permits and commence work, and completion within 20 days of the issuance of permit. Certified mail receipt was not received. However, the USPS tracking website showed that it was delivered May 9th, 2019. And through various phone calls with the owner, she did acknowledge the violation. So this is the property. It's in North Greenwood. It's just east of Myrtle, and it's between Seminole Street and Palmetto Street. This was back in January 2015 when the fire first occurred. This is the back of the property. It shows the extent of the damage. Pretty much well destroyed, right? You can see the hole in the roof, the interior's gone. This was in June of 2018. This is when I took over. You can see they've done some work. They did have an expired permit at this point, but up prior to it expiring, they were getting inspections done. Again, that same day. Shows they got a new roof, some new windows. And then this was this month, 11/4 of 2020. You can see their infiltration barrier up on the front. They're still in the process of correcting this. Their permit is still active. However, they're not complete. Part of the stipulation with an unsafe structure is that they do complete that permit. And any questions?
Is there anyone living in there?
They're not. They're currently working on it though still. I did speak to Miss Alon this morning, and I let her know the recommendation we were going to seek, and she was okay with that.
Any additional questions from the board? Can you give us the city's recommendation?
Sure. For compliance to be met for the unsafe structure would be repair or replace any areas where deterioration exists to meet current Florida building codes. All work must be properly permitted, and the permits must be completed. And for that, the city is requesting compliance on or before February 18th, 2021, or a fine of $25 per day that the violation continues to exist, and any reasonable cost to be applied as liens against the property. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law.
Mr. Chair, I have a question. Is this a residential structure or commercial?
It's residential.
Any questions from the board? I acknowledge that $25 per day seems fair.
Yeah.
Understanding that they are making progress, they seem to be attempting to remedy the situation when you have the ability to put a much higher fine.
Correct.
Yeah.
That's why we did that.
I think that was fair on the city's behalf.
They're very close to the end. They've only got a few inspections left that they need to accomplish to be complete.
Interesting. No additional questions from the board? Okay, on this one, we'll need a second motion, but just be sure that it's from the unsafe building page.
I move to enter an order requiring the respondent to correct the violations on or before February 18th, 2021. If the respondent does not comply by that date, the board may order a fine of $25 per day for each day the violation continues to exist, and the city may take all reasonable actions, including entry onto the property, to bring the property into compliance and charge the respondent with all costs, which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such a lien is filed, the city is authorized to foreclose, collect, or settle such a lien.
I'll second that motion.
Motion is made and seconded. All in favor?
Aye.
Any opposed? Nay. Motion passes.
Thank you.
Thank you. Moving on to 4.9, continue from 3/25/20, 4/22/20, 6/24/20 and 7/22/20, case 90-20. Find respondents at 1447 Druid Road Land Trust at 1447 Druid Road in violation of code for permits, and issue an order with the compliance deadline and fine if compliance is not met. Is there anybody here to speak to that case? No? Okay, board, we will need a first.
I move to find the respondent in violation of the code as referred in the affidavit in this case.
I second that.
Motion is made, seconded. All in favor, aye.
Aye.
Opposed, nay. Motion carries. Yes, ma'am.
Good afternoon, Hilda Espinosa, Housing Inspector for the City of Clearwater. I'm here to present a case at 1447 Druid Road. It's for a stop work order. They need permits. It was doing a roof. This is a residential property. Notice the violation was sent out in October 7th of last year, and again in March of this year, March 6th. Compliance date was October 24th, and again in March 26th of this year. Certified mail was received on 10/24 last year and March 26th of this year. Also sent out regular mail. Excuse me. Notice the hearing was sent out March 9th of this year. Certified mail was received on 10/14 last year, and again April 16th of this year. And I did an affidavit posting on March 9th of this year. This house is just west of Highland, south of Gulf to Bay, and just east of Missouri. This is what the house looks like. As you can see there, where the arrow is roofing material. If this house was in foreclosure, the former tenants were out. The bank took it over. I do not know who started the roofing. Could have been the bank. It could have been the owners now. Don't know. This is a photo of the stop work order that I posted on the window. This is what I found when I went out there. You can see all the wood, all kinds of debris, construction debris. This is new rafters. This is on a flat deck, flat roof. You can see new sheeting. This is at the back of the house. That's what they're trying to repair. This is the way it looks, and it still looks that way. You can see they put down new roofing tiles. This is a photograph of the affidavit, the posting, and that's it.
Have you been in communication at all with an owner?
I will tell you that they came in last year, I believe was November, maybe October. They had applied for a permit. They could not get a permit. They needed 2 contractors. Roofing contractor cannot put down the rafters. That has to be a general contractor. They never contacted back or anything.
Gotcha. Any additional questions from the board? I think for clarification that we understand there was obviously and apparently work done to a roof, and the question is there was no permit pulled.
Yes,
and
sir.
that's why it's before us today.
So are we looking, Mr. Chairman, are we looking for a violation of not only a roofing contractor, but also general contractor?
No.
We're looking for a violation of not pulling a permit to do the work.
I see.
Yep. No other questions from the board. We'll have a recommendation.
Okay. It's one violation. Compliance can be met on or before December 30th of this year, 2020, or $150 per day. I have per violation. That should be per day. And after 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law.
Thank you.
and that can be remedied by applying and obtaining a required permit.
Thank you. Comments from the board?
What about the material removal?
Go ahead.
What about the material removal, the existing?
That's
material?
gone already. As soon as I posted it, the next day, somebody came and took all that trash and threw it away.
So someone's paying attention.
Mr.
It's still
Chair.
sitting there, it's still for sale. They can't do anything, they haven't done anything. Getting regular phone calls from the neighborhood, what's going on, what's going on.
Mr. Chair, did you have a question?
Yeah, so what we're looking for is two permits. They have to have a general contractor and
They can,
a roofer.
I'll let Dana Root, Assistant Building Official, answer.
Good afternoon, Board. My name is Dana Root. I'm the Assistant Building Official for the City of Clearwater. What they've done is they re-roofed the house, and in that process of the re-roof, they probably found some damage, and they did some framing. So that would require one permit, and that would require a roofing contractor and a general contractor, or they could have two permits if they want to. So it could be one, it could be two, but they do need a roofing contractor and a general residential or building contractor to do the framing work.
Thank you. Any questions or comments?
No.
It's a relatively straightforward case for us. We see the work has obviously been done and no permits were pulled, and according to Clearwater Code, that's in violation.
The roof in the front is done, the back is a different story.
Perfect. So what we'll ask the board is a second motion being made.
I move to enter an order requiring the respondent to correct the violations on or before December 30th of this year. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day, per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such a lien is filed, the city is authorized to foreclose, collect, or settle such lien.
I'll second that.
Motion made and seconded. All in favor, aye.
Aye.
Opposed, nay. Motion passes. Thank you, Ms. Espinosa.
Thank you.
Moving on to case number 4.10, continued from 3/25/20, 4/22/20, 6/24/20, and 7/22/20. Case number 9120, Fine Respondents Trust, 1917 William Asset Conversion, Inc., Trey at 1917 Macomber Avenue in violation of code for permits, and issue an order with the compliance deadline and fine if compliance is not met. Is there anybody here to speak to case 4.10? No? Okay, board, we will need a first.
I'll make I move that we find the correspondent or the respondent in violation of the code as referred to in the affidavit in this case.
Yeah.
Second? Anybody?
A second.
Okay, motion is made and seconded. All in favor, aye.
Aye.
Opposed, nay.
The city is going to ask for a declaration of violation. They applied late yesterday for a permit, and the permit was active this morning, which I did not know until I looked up.
No problem, makes our job easier. So what the board's going to be looking for is a declaration motion on that.
Okay.
Sorry.
Yeah, I'll make a motion to withdraw my previous motion.
Thank you, sir. And then a motion for declaration.
I'll make the motion to declaration. I move to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Do I hear a second?
Second.
Motion is made, seconded. All in favor, aye.
Aye.
Opposed, nay. Declaration motion passes. Thank you, Ms. Espinosa.
Thank you, board.
Moving on, case number 4.11, continued from 3/25/20, 4/22/20, 6/24/20, and 7/22/20. Case number 93-20, find respondents Gary English at 3131 Downing Street in violation of code for permits, accessory structure, and issue an order with the compliance deadline and fine if compliance is not met. Is there anyone here to speak to case number 4.11? Sir? Sir, if you would please step up and state your name and address for the record. Take your time.
Yes, my name is Gary English.
Thank you, Gary. And do you admit to the violation? And that's just how the procedure works on the board. You admit or deny, and then we move forward.
No, I really don't admit to it because the history from the last time I was here in front of you people, I was contacted by a building inspector, and he left me a code book with underlined areas of where I was out of compliance.
Okay.
And that was, I had a travel trailer in my front driveway, and that wasn't correct, and I removed that. And the boat on the side of my house said it must be, covered up, and left me to meet either fencing or hedges. And so I comply with that, and I put the fence up, and I called the inspector. He came back out and inspected it, said, "You're in compliance, good to go." And then a month after that, I get another notification, that I'm out of compliance on a different subject.
Okay.
I mean, it's just,
Yeah.
what did I do? Tell me the first time, try to correct it, and then it didn't go like that. It just
Perfect.
seems like they're,
And that makes sense, and we'll get some
Picking on you.
clarification here. So how the procedure works, if you'll have a seat in that front row, we'll let Mr. Contrell in the city come and hopefully give you some clarification. We'll see how we can help you remedy this.
Okay.
Thank you, Mr. English.
Good afternoon, Board. Jason Cantrell, Building Inspector, City of Clearwater. This is case number 93-20 for an accessory structure and case 94-20 for a fence at the property at 3131 Downing Street. Just to clarify on what Mr. English said, he said a building inspector. He was actually referring to the code inspector that he spoke with. That case is on the docket at the end of the day today. Moving forward, here we have two violations. For both of them are stop work orders, work without a permit. Citing code section 4-203A1 for a permit required. That is for both cases, 93 and 94. Articles 4, section 47.083, subsection 2 for work commencing prior to permit issuance. That again is in reference to both cases. And the final code section 3-203B and D is only in reference to the accessory structure, setback height, and limitations. Notice of violation was sent on February 6, 2020. Compliance date from the date of receipt of each notice, 21 days to obtain the permits. Certified mail was not received, so it was hand-delivered to Mr. English along with the notice of hearing on March 24th, 2020. This property is just off of McMullen Booth, just north of Gulf to Bay. On January 21st, 2020, Inspector Espinosa took this photo for me, and this is the arrows pointing to the accessory structure in question. One of the height limitation for accessory structures, it cannot be taller than 15 feet or the height of the structure, whichever is less. Is clearly higher than the structure. February 5th, again, you can see that structure. That's a better angle. You can see it's much higher than the house from there. And then the two arrows are pointing to the fence posts that were installed. Fence panels themselves may not require a permit, but it really depends on how they're anchored. In this case, he's using fence posts, and those would require a permit. There's another view of another one of the posts. And this is inside the structure. Mr. English allowed me in there to show me how he affixed these panels to the structure, which how he affixed them still wouldn't be allowed because one, the structure itself would need a permit, and also the structure itself is anchored to the ground. So even if he's using that, it would still require a permit. And this was on 10/23, just to show there's no change. He did complete the fence that he put in. And I'll pause for your deliberation.
Does the board have any questions?
Yes, I have a question. What is that? Is that another boat outside the structure? Is that his property? Could you put that slide back up?
Right there, that is actually not his property. The fence is approximately on the property line. Where that RV is, which is no longer there, is a county property that he was storing his RV on. So no, that's not part of the property.
Any additional questions from the board?
The boat cover exceeds the height of the house.
Correct.
And so that he would not be able to get a permit for that regardless.
Not as it sits, and also there's other community development regulations that wouldn't allow it to be in front of the principal structure, which in this case it is.
Okay,
So
I understand.
So he would have to get a permit.
he would have to get a permit, and he would probably have to shift some things around, but it is possible to keep possible.
He'd have to move the boat and the structure to the front property line.
He would need to come in and apply for the permits first and get approved, and they would let him know.
They would deal with that.
Yeah.
Have you spoke with him on several occasions to clarify the understanding of this? Because it seems Mr. English came in not understanding the city's position on it.
We did, and I kept referring him to Inspector Odegaard and Mr. Peaslick from Code Compliance to deal with his concerns with what he believes he was told. That's between them, and I let him know what he needed with us.
Okay, so basically it seems like the remedy is a permit for the fence that wasn't permitted.
Correct.
And then the structure that's higher than the roof would need to be either lowered or...
Correct.
Okay. Any additional questions from the board? Mr. Cantrell, can you give us the city's recommendation, please?
We need to hear from Mr. English first, as regarding this issue, whether a violation exists.
Mr. English, would you step back up, please?
Pardon me, I didn't hear the question.
That's okay.
Basically, the chair's going to ask you what you have in response to what the city.
Yeah, did that bring any clarification for you, Mr. English, on what the city is saying needs to be done to remedy that?
No, I couldn't really hear everything he was saying, but he came out to my house and, I explained to him the history, where I put the fence up. It's actually carport siding, so I didn't see any category for carport siding. Fencing, yes, there is a category for permit. I did install 2 posts, but I didn't think you needed a permit to install 2 posts and cover the boat up. And when the inspector came out, he said, you're fine, you've done what you're supposed to. The structure, the carport's been there since 2010. Okay, I think what attracted attention is probably my travel trailer, which is gone. The other boat is gone. Only have the travel trailer. I rent that property from the owner in order to store the travel trailer there. So, I really don't understand that. And what I need to do, according to the first inspector, and then the second round, you also did this, this, and this. Well, it's been there for 10 years.
Right.
He left me the code book, underlined, I have it right here, what needed to be done. I did it. And then a month later, somebody else comes by and brings up a new set of rules. That's the way I see it.
And we want to be, somewhat understanding and compassionate towards the situation, obviously, when you say it goes back to 2010. Unfortunately, there are codes that we all have to play by, and the city is stating in front of us that to fix your violation, you need to apply for that fence permit, whether it's carport siding or fence, it's whatever we want to call it, which it should be a relatively simple fix. And then the second thing is fixing your carport structure that has to be as the height of your roof or lower, if I'm understanding that correctly, Mr. Cantrell?
Correct.
Yes.
That's impossible. I have to tear it down. I have to take it down. And then do I leave the carport siding, or whatever you call the fence?
That,
And just take the roof off, and
that's
that's what I'm gonna be forced to do.
yeah, that's
Because it's 2 feet higher than my house or something.
yeah.
Yes?
That would be less expensive than building a second story, I think, so that might be our only remedy of the situation to appease the city on the code portion, is to apply for that permit or take your fence down and figure out the height of that carport or the boat cover.
I can't lower it because we'll hit the bar. Just that simple. So I'm not allowed to have a carport that covers the boat.
You can, just not one that tall, is what the city's telling you.
I have no choices.
Yeah.
Tear it down.
And again, we don't have, the ability to make changes of those codes or to tell the city to, grant you leniency. Unfortunately, it's a
I'm
code.
surrounded by county property. I don't think it's a problem in the county. Everything at that end of the street, just about, is county. It's at me. I'm in the city.
Right.
Nobody else seems to have a problem with it. None of my neighbors have a problem with it.
Unfortunately, when you become on the city's radar and it's in violation, they have a job to do and they have to interpret the codes. And we're in violation as of now as we sit, Mr. English. So as a board, we're given no other option other than to support the city in that sense. If it's a code, it's a code. And
so, and then if I do this, and then next month, is somebody gonna come around and change the rules again and make up a new set of violations? Or
I don't believe the code changed.
Couldn't we do it all at one time from the very beginning? That's my beef with this process.
And I agree, and I feel your frustrations as well. I think it wasn't a code that changed on you. I think it was probably the previous interpretation and enforcement was different than what you're dealing with now, and that's
the code didn't change. I mean, I have the underlined areas where I was in violation right here from the very first time.
Yeah.
And it doesn't say anything about permits or height of the structure or the carport. It has none of those. I mean, I'll be glad to give it to you.
Yeah, no, I'm fine. I can only go by.
It doesn't have anything about the height of the structure or the carport being illegal or too high, or, it just said that, and the last time I was here, just to put up a fence to block it from view. That's what I did. And he tells me everything's good.
Mr. Chairman.
And now I have all these other problems.
Yeah.
Where does this end?
Right.
Yeah, Mr. Chairman,
Yes,
could the gentleman go back to the city of Clearwater, the building department, and apply for a permit, knowing that the structure is going to be higher than his residential use, and then be denied a permit and then appeal as for a variance or a special exception or some other method of allowing this structure? Is that possible?
That'd probably be a question for Mr. Root. I don't. Mr. English, would you mind just stepping aside for a second? Yeah, no problem. You're good. You can stay right up here so you can hear. I want to make sure you understand. We want to help you the best we can to remedy it, but they have to enforce it, and we as citizens abide by it. So hopefully there's somewhere we can meet in the middle.
Yes, he could apply for a flexible standard, or if you want to call that a variance. He would have to prove that that the surrounding properties, or you would have to prove that what he wanted to do would be consistent with the surrounding properties, meaning that there was many other properties in the area that had similar accessory structures, the height in front of the primary structure. There may be an issue with the side setback of 5 foot. So he's probably got 3 things he has to deal with: the height, that carport being in front of the primary structure, and also being too close to the property line. But without him talking to a planner, giving them a survey of the property and discussing what he wants to do, that's part of the process of getting a permit.
Okay, thank you. And good, very good question.
How long that process takes?
not sure of a timeline, but there is application and there is a fee. Maybe Lauren, do you have it for FLS?
Hi, good afternoon, Lauren Matsky, Planning and Development. For the first level review, assuming that it could be approved through that, which is what we call an FLS, that takes about 6 weeks. So applications are accepted at the first business day of each month by noon, and those are reviewed by our Development Review Committee. That committee meets the first Thursday of the following month. So everything at that point depends on the completeness of the application, any responses to comments and things like that. But if everything was complete, it generally takes 5 to 6 weeks.
Okay, thank you so much.
You're welcome.
Mr. English, you want to step back up? So it seems we're finding some avenues for you to possibly make this work. You just have to remain in an open line of communication with Mr. Cantrell, so you're not wasting time or money that isn't part of the code and isn't legal, and then, hopefully.
You know how many times I've called various people? Mr. Cantrell did call me back at one point, but he was going to contact Brian Odegaard's boss, whoever that may be, and have them call me. Nobody's called me. I've called down 5, 6 times. Nobody called me back except him.
Okay. I apologize for that, but hopefully what we can do is remedy this going forward. Is unfortunately, we're in violation as of now, as a board. We're going to have to make a decision, but we are supportive in the fact that you do have avenues to go down to hopefully fix this problem. So we would just, as a board, urge you to stay in open communication with the city. Mr. Cantrell.
I would like to.
Yeah, Mr. Cantrell is great at communication. Mr. Peislak's here as well. So if you have questions, Mr. Root's here, grab business cards and hopefully remedy that. But from the board standpoint, we have to issue an order going forward because we are in violation as of now. So
what I'm hearing is that what I was told to do to be in compliance now must be removed. Okay, that's what the fence has got to come down, the carport's got to come down, roof's got to come off of it. So what I was told to be in compliance, and after the inspector came back out and said I was in compliance, you're good to go, now I have to remove that. That's what I'm being told.
not
And
necessarily.
I don't think it's fair at all.
I agree. Let's just do it one thing at a time. I think your fence, if you're going to keep your fence up, go through the permitting process for it, and then if you're going to have time, we're going to issue an order. It's going to give you, the city's going to recommend time that gives you time to start these processes. We've just been told it's probably going to take a 6-week application process if you are going through building and trying to erect a legal structure. I don't think the end answer is tear it all down and start all over. I think you have to go through those channels and figure out what answers we can get for you.
Well, they're saying it's beyond my property line, but, I mean, it's in front of my property line by, I don't know, 5 feet or something.
Yeah.
But if I covered that I would be in compliance. Now, if I can't have the fence, and I can't have it 5 feet in front of the property line, then I've got to remove the boat, tear the fence down, tear the carport down. Understand? Because it can't go back any farther.
I get it.
Air conditioners there.
And we're not sure of those rules and codes and that process. That's not what we're here for. We can be understanding and as compassionate as we can. We can grant you a little more time because the processes take. But I think your best remedy is keep those open lines of communication, follow the processes, and hopefully you can come to a understanding and an acceptance.
It's not fair. You told me the first time.
Does the board have any additional comments or questions? If not, can we go ahead and make a first and a second and move through it? So if somebody would make a first motion, and then we'll come back with the city's recommendation behind that.
Yes, Jason, you did both cases in this presentation. So this is items 4.11 and 4.12, cases 9320, 9420. They were broken up into 2 cases, one for the fence, one for the accessory structure.
Okay,
So we need two motions. Actually, total of four, because we have not done.
this one here.
Can we start with two first for each one?
Yes.
Mr. Cantrell gives us his recommendation, and then we can follow it.
You can make your declaration first, and then your determination of violation exists or doesn't exist first on each one.
Okay, so board, what we'll need is a first motion for 4.11, followed by a first motion for 4.12. We can do those separately and then move through with the city's recommendation.
Okay, I'll move to find the respondent in violation of the code as referred to in the affidavit in this case, and that's for the accessory structure. And then I'll also make another motion.
So let's go ahead and have a second.
A second on the first motion.
I second it.
Okay, motion is made and seconded. All in favor?
Aye.
Those opposed? Nay. Okay, now you can make the first motion on the second.
And I'll make an additional motion to find the respondent in violation of the code as referred to in this affidavit, in this case, and that would be for the fence.
Okay, first motion is made. Can we have a second?
Second.
All in favor, aye.
Aye.
Those opposed, nay. Okay, so Mr. English, if you would just either have a seat there or step aside. Mr. Cantrell is going to give us a recommendation from the city.
Just to clarify, if, hopefully Mr. English is able to obtain permits, but if he does for both the fence and the accessory structure, he will need to make sure he meets all of the community development codes. And he would have to rectify those. Just obtaining the permit and doing nothing with the structure or fence wouldn't suffice, so I just want to clarify. For compliance to be met for the stop work orders, apply for and obtain permitting for the accessory structure and the fencing, meet all community development requirements associated with those permits. Alternatively, the fence and structure can be removed. The city's recommendation is compliance on or before December 18th, 2020, or a fine of $150 per day per violation that the violation continues to exist, and any reasonable cost to be applied as liens against the property. After 3 months from the recordation date of such liens, if the fines, fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law. And we have no objection if you wanted to alter any of the times or fines.
Yeah. Okay, thank you, Mr.
Yeah.
Cantrell. Mr. English, would you step back up? So what the city is initially saying is they were requesting you to comply by December 18th of 2020, or a fine of $150 per day would start accruing. What they're saying is to grant you some leniency because your availability to go through other channels and building and permits and stuff, they're willing to grant you more time, and that's something that this board can do for you. So if the board is unanimous in that decision, we would like to give you a little bit more time in that process. But do you understand what you need to do going forward? Because we don't want to see you start accruing these fines either.
Thank you for extending the time, because I have some the holidays and medical issues, and there's some other things that I need to attend to. More important, but no, I'm not exactly clear because of the setback in the height.
Mm-hmm.
So if I could bring the height down, am I okay? Doesn't sound like it.
This board can't tell you whether you're okay or not. You have to talk to the inspector about it.
I just need it really clear because I've gone through a lot of steps to comply, and now I'm not in compliance.
Right.
It's cost me a lot of money, and it's still going to cost me a lot of money and time.
Yeah. We're understanding and compassionate of that, and again, the best we can do as a board to help you out in this situation is to make sure you're understanding of what you can do to remedy the situation, so you're not collecting more fines and fees because you haven't started yet, and we're willing to grant you more time, is what the city's saying. So, I mean, I don't know the board's position, but I don't have an issue granting them an additional 30 days or something.
I say more. We're in the middle of a pandemic and this is not a safety issue.
So do we want to say 6?
We're talking about 6 weeks for permitting. This is an older gentleman with health problems. I have no problem even more than 90 days.
So now you're looking at either February or March. I don't have a problem with it if anyone wants to make a motion on it and move forward. That'll give Mr. English plenty of time through the holidays.
Mid-February.
And what we will need is two separate motions as the second motions, two separate for case number 4.11 and then 4.12.
So then I move to enter an order requiring the respondent to correct the corrections on or before February 18th, right? And may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such a lien. So instead of 30 days, you now have 3 months.
Okay, first motion, do I have a second?
I'll make a second.
Okay, motion is made and seconded. All in favor, aye.
Aye.
Opposed, nay. Okay, perfect. So that's 4.11, February 18th. You have to get that running. Second motion on 4.12.
You know, is it up to Mr. Cantrell to explain to me exactly what I have to do?
Absolutely. When you leave here, we want you to make sure.
I won't go through a bunch of steps and then be back in here.
Totally understandable. Let us finish this second motion and we'll make sure that you have those avenues of communication. So we'll need a second motion, very similar to the first one you just did. This one for item 4.12 and granting February 18th at the same.
Didn't I just do that?
We have two separate.
Oh, okay, so this is 4.13? No,
4.12.
1.2.
You did
So I-
4.11.
Okay, so I move to enter an order requiring the respondent to correct the violations on or before February 18th of 2021. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, and settle such a lien.
I'll second that.
A motion is made and seconded. All in favor, aye.
Aye.
Opposed, nay. Motion passes. Mr. English, thank you. If I were you, I would make sure while you have all these ladies and gentlemen in the same room, pick up their cards, make sure you have those lines of communication, and they will be the professionals that will give you, hopefully, that correct advice so you're not wasting any more time and money. Moving on, agenda item 4.14, continued from 7/22/20, case number 100-20. Fine respondents John and Lori Sorelli at 865 Bruce Avenue in violation of code for short-term rental, and issue an order with the compliance deadline and fine if compliance is not met. Is there anybody here to speak to case 4.14? Yes, sir. Please step up to the podium and state your name and address for the record.
Were you sworn in, sir? Just raise your right hand. Do you swear or affirm to tell the truth throughout your entire testimony?
Yes.
How are you, sir?
Good.
State your name and address for the record, please.
John Sorelli, 865 Bruce Avenue.
Okay, Mr. Sorelli, do you admit to the violation?
No.
No, okay. Do you want to chat with us briefly about it?
Yes, so basically what happened is I get a letter on my door saying I was in violation of advertising. And I don't know if it was coincidence or whatever, but we have nosy neighbors who walk around looking at out-of-state license plates and saying they're renting. Well, my stepson and grandkids came in May, North Carolina plates. They stay there. The day after they left, I got the letter saying I was rented. I haven't rented. I rented to 3 people a year, January, February, and March. That's it. I don't rent by the week, and I approve it. You can look at the sales tax. And when I got the letter, I called the person, and they said, you're advertising. I said, I'm not advertising. It says monthly rentals only. I said, well, I could put it in a week and you could book it. I said, no, you can't, because I have a program where you have to tell me that it's going to be rented, and I have to prove it, and I tell them I could only rent by the month. And then she started saying to me, well, I could put it in, and I could see all these dates that you have. Well, if you're not an owner of that website, I block it, because I don't want people to rent it. So it says block, 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 but when you look at it, it looks like it's somebody there being rented.
Gotcha.
So that's my beat. But I approve, I mean, basically, I use Belize, I guess it is. They rented January, February, March for me. I do use home away, and I do try to rent, but some peak times I don't want to rent, so I just block those out. And that's basically it. And I can understand somebody looking at it and saying, well, wow, this guy's renting a lot. I don't rent a lot, I don't want to rent a lot, but I got to pay the taxes here and everything, and I try to make a little extra income, and most of the time I rent it during the winter, by the month.
Okay, Mr. Sorelli, I thank you for that. If you don't mind, have a seat in that front row. We'll have Ms. Phillips of the city come up and hopefully bring clarification for you.
I have a question.
Go ahead, you can ask a question.
Is there a business tax receipt for this property? Oh, okay.
Good afternoon, Board. Julie Phillips, Code Inspection Specialist for the City of Clearwater. I'll be doing a presentation on 865 Bruce Avenue, case 100-20, and this is a repeat violation. There's one violation at this property. It violates Code Section 1-104B for a development code violation and Code Section 3-919 for prima facie evidence of certain uses in residential zoning district, which means advertising of an illegal short-term rental. This property was posted with an affidavit of posting and notice of repeat violation on May 19th, 2020, and it was also sent certified mail. Section 802, the definition of a residential use, means a permanent place of residence for a family. A residential use located on residentially zoned property shall not include rentals for periods of less than 31 days or 1 calendar month, whichever is less, or which is advertised or held out to the public as a place rented for periods of less than 31 days or 1 calendar month, whichever is less. A residential use located on residentially zoned property shall not include interval ownership, fractional ownership, or a time-sharing unit. So the definition of a repeat violation means a violation of a provision of a code by a person who has been previously found through a code enforcement board or any other quasi-judicial or judicial process to have violated or has admitted violating the same provision within a 5-year period, withstanding the violations occur at different locations. On March 22nd, 2017, case 46-17 was brought before the Municipal Code Enforcement Board and was found in violation for Code Section 1-104B and 3-919, advertising an illegal short-term rental. The property was brought into compliance prior to the board hearing. The board ordered that no fine be imposed. If the respondent repeats the violation within a 5-year period, the board may order the respondent to pay up to $500 for each day the repeat violation continues. The respondent was not present. This is a picture of 865 Bruce, and this was taken on May 19th, 2020. This is my affidavit of posting, which was posted on the door for a repeat violation. I did receive a call from an anonymous neighbor. He advertises on the homeaway.com website. This was taken on May 19th, 2020. And if you look at the minimum stay where the yellow arrow is, it's a minimum night stay of 1 night. For a residentially zoned neighborhood, it has to be 31 days or 1 calendar month, not 1. So it doesn't matter whether he has contracts of people staying there at night, it's the advertising. I did try to book the property from September 5th to the 12th, and I was able to do so. You can see for 7 nights, it was $229 a night, the total of $1,257, and that was on May 19th, 2020. You can also see the month of May, there's 2 weeks booked out, and in June there's 2 weeks, so it's not consistent with 31 days or 1 calendar month. Again in July. And I went back to the website, VRBO. VRBO and HomeAway are the same company. Again, minimum stay 1 night. I tried to book it November 7th through the 14th, was able to do so again for 7 nights for $1,257. And then when the owner actually got the notice back May 21st, 2020, he went ahead and changed it to 30 nights. So it's very easy to do that. Again, I tried to book it, and then it was changed to 30-night minimum stay. And I'll let the board deliberate.
Does the board have any questions for Ms. Phillips?
So what happens to the ones that were booked? Do they get canceled out for less than 31 days that you made? previous day.
What I'm going after is the advertising. So again, if you have a short-term rental, it has to be 31 days or 1 calendar month, whichever is less. So the owner was brought before the board previously and brought it into compliance. Had he left it in compliance, there wouldn't be a problem. Short-term rentals is such an issue on Clearwater Beach. Neighbors do look at neighbors, and when they find somebody doing something, they report it, and I enforce on it. So the contracts don't make a difference. I'm not looking at license plates. I mean, I have family that lives all over the United States, so license plates to me do not make a difference. It's the advertising.
What do the websites say now?
He changed it to 30 days. It's in compliance right now, but he was in violation for 2 days.
Any additional questions from the board? And was the previous violation for the same exact property?
Yes.
And was it remedied in the same exact way?
It was corrected prior to the hearing. There was a declaration of violation, making this a repeat violation.
So he changed it from the 1 night back to 30, and then some period of time went, then it was flipped back after it was, the case was, okay. Are there any additional questions from the board? No? Mr. Sorelli, would you step back up, please?
Yes. So the first violation was basically a review. I didn't do nothing. Somebody put in a review, and they were calling that advertising. I didn't put it up. The person put it up. When I got a call about it, I had to go call the person who put the review up, tell them to call home away, take it off. Because you can't do it. You can't put a review. That's the reason it was violation, because somebody put a review on there that they stayed there. And I couldn't do anything about it. I had to actually, embarrassing, call somebody who stayed there and tell them, please take the review off. And she didn't know how to do it. She had to call him away, and that's the reason I got that. If you look at that calendar, it says Old Gray. That's not bookings. I block it, and I can show proof that it says blocked on my website. I took a photo of it, because when you take a picture, it doesn't come out on a printer. And then, like I said, yeah, she is right. She's not looking at license plates, but the people who basically tattletelling me are looking at the license plates, because it happened a day after the people, my family, came from North Carolina.
Yeah.
I mean, and then I also said, how many days can I put in? And she just said 31 days. So what happens to 30? Well, you could put 30, some 29. I mean, if you go on the website right now and you put in no dates, look at all the people advertised less than 31 days. So I just want to be right. I want to be fair. I just want to make sure I'm doing the right thing. But if other people are doing it, I'm not saying I'm going to do it too. I put it in, and that's how it is. But honestly, it seems like people are doing it until somebody gets caught. And a realtor told me the same thing. You basically, if it's on the website, it's fine. But somebody says, "Oh, I caught you," and then this all starts.
Yeah.
Because that first violation was 2017. I didn't really change anything.
Yeah.
The only thing I had to change was taking that review off. I didn't change dates, it's taking a review off.
Mr. Sorelli, why would a guest that stayed there or didn't stay there get on and leave a review of a time that they stayed when it not be
Because I put in, I blocked the whole month and they only wanted to stay a week. I didn't have 3-week rentals. I don't rent a lot. Like I said, if I rent, it's 3-4 times a year, tops, and it's spread out. That it's put it this way. The way I was called upon, I was told that they're sick and tired of you renting all the time. It's not true.
Yeah.
It's not true at all. I'm only rented 3 to 4 times a year, and 99% of that time is 30 days, 60 days, whatever. You can look at my sales tax records and look at all that. There's nothing in there that says I rent by the week.
Okay, a couple things. I don't think it's possible. I know the city works quick sometimes, but it wouldn't be possible for them to see a license plate in your driveway today, and tomorrow you're getting a notice in the mail. So that probably didn't happen that exact quick. Secondly, I think that we've already went through this, and
Right.
you've been through this process, so you understand the game and how to play it, and you switched your amount of days from 1 to 30 so that you could appease the city and staff, but then in your understanding of what was wrong,
Right.
but then we flipped it back to 1 again once a time period went by, and then the excuse of everybody's doing it, well, I mean, we're all
You're right.
speeding on
That's-
US
that's-
19
I don't
and
wanna-
you
I
get a
don't-
ticket.
right,
It
I
doesn't-
don't- right, you're
we
right.
can't tell the cop that, well, everybody's speeding,
But
you're gonna get a ticket.
honestly, I thought it was, if I say, no, you can't do it, because it doesn't say really advertise, I have in monthly rentals only. But after I talked to the woman, say, no, you can't do this, you can't do this. So then I changed it, but then I said, well, is it 31, is it 29, is it 28? What is it? Is it 31, 29? I mean, what could I put in there? But I guess the bottom line is, I'm not doing this to trick anybody.
Yeah.
I just want to do it the right way, and I thought I was doing it the right way, because when somebody says it, and I could prove it, I put in, sorry, I cannot rent by the week.
But
So,
Ms. Phillips did not get that reminder when she tried to rent it for 7 days.
but what I'm saying is, she couldn't book it. Even though it said she could book it, I have to review, and I'll show proof of that. And that's when I do it.
Right, and,
It-
I mean, that's an argument that's tough for the city to, how are they gonna prove that, I mean, if you
Well,
allow
yeah.
it to happen,
It's,
the
right.
the system isn't set up for you
I
to be
understand that.
the
I mean,
gatekeeper and
I
saying,
guess what I'm trying to say is, I'm being honest and saying I can't do it, but as a city part of it, you could say the other way. You could say I'm not doing it. That's why I changed it. I'm not doing it
exactly.
anymore.
So what she brought in before us was, you're in violation because you're advertising it.
Right.
She's not saying you're collecting money, she's not
Right.
saying, you're in violation because you're advertising it.
Right.
And you did previously,
Right.
and you remedied it, thank you
Right.
for doing that, you saved yourself time and money and city staff time and money. But then, here we are, right back in the same exact situation.
Yes.
When we already know what we can and can't do.
And I thought I could do it as long as I tell the person I can't do it. Because if you
Right.
go online, it says
Yeah.
monthly rent only, and if you try to book a week, you can't.
I get it.
You can't.
You have to understand that these short-term rentals, especially on Clearwater Beach, come before the city often.
Yeah.
Because and not just because they're nosy, because they protect and care about their neighborhood that's,
And
been disappearing because of building.
Right.
And the little bit they have left, and now rentals
I
become
understand.
a problem.
And I understand
so
the rules now, and like I changed it. And then
Even if
the
it's your,
violation, when I got that letter, I called that day and left a message. Nobody called me back. The next day, I called, I talked to her, and I took it off that day.
gotcha.
It's not like I'm not,
Right, I get it.
yeah.
From the city standpoint, how would you like the board to move first? Do we want to hear a recommendation? Would we like to hear a?
Well, you have to determine the violation.
Does anybody else?
Just so you know, this is a repeat, so
And the repeat is what I told you about. It was a review that I didn't even put on, and I took care of it right away.
Yeah.
It was a review somebody put down.
Mr. Chair, may I ask a few questions?
Yes, sir.
Thank you. Is it Sorelli?
Sorelli.
Excuse me, Mr. Sorelli. My name is Michael Paulino. I'm Assistant City Attorney. Now, this property, it's not your house, right? It's not your homestead. You live in Newport Richey?
Yes.
Okay. And you've lived in Newport Richey since about 2003?
Yeah.
Okay. And that's always been your homestead, right? And that's always been you and your wife's homestead?
Yes.
So why in 2017 and 2018 did you apply for and obtain a homestead exemption from the Pinellas County property
We were
appraiser
gonna
for
move
this
there,
property?
and we decided not to, because my wife was gonna change jobs, and that's why I took it off right away.
But you were renting the property out in 2017,
I.
which is why you got the first violation, right?
Right,
Okay.
Right.
And you don't rent out your homestead, right?
I don't, right.
Okay.
Right. Yeah, that's why I took the home, because I saw a letter saying you're not allowed, so I took it off right away, because we were gonna move there, and when I realized that you.
So this property was never your homestead?
No,
Okay. And so you really should not have applied for a homestead exemption?
right, well, which I didn't know. And that's
So
why I took it off.
if you incorrectly told the property appraiser something, why should this board believe you when you say you have not short-term rented this property?
Because when I did a homestead, I didn't know you can't do a homestead, and that's why, and when I found out,
But you've had a homestead in Newport Richey for 2003?
yeah, and I
And
owned
you've had- and
it,
you-
I lived it.
And you've had an exception, and you had the exemption on, for, what, 17 years?
Over there, yes.
Okay.
And I was gonna move there, and then they decided not to.
I don't have any further questions.
Yeah, like I said, it's a little confusion going on. I understand your side and on my side. I'm not trying to, I'm not a person who's renting 20 times a year. I'm renting it 3 to 4 times a year, and that's it. There's only like 4 or 5 people. When somebody tells me they're sick and tired of somebody you're renting in and out, I don't know what they're talking about.
And I get it, and unfortunately, you're advertising it, so you are lumped in, whether you do it 3 times or 74 times.
Right, I understand
you're-
that.
You're in violation, so.
I understand, I understand what I did. I was wrong. I do what I could do by saying you can't rent by the month, even though I put in monthly rentals, and I do it if it was in there, and I tell them, because you can't book it unless I say you could book it. I do what I was given.
I got you, okay, no problem. Does the, yes, sir?
So here's the issue. A repeat violation, if you find him in violation, for the days that he has violated, in this case I believe it's 2, the fine occurs immediately, okay? So if you determine that there is a violation, then there should be a fine for those days that there was a violation, up to $500 a day. That's the difference between one where you give somebody an opportunity in the first scenario to correct it. Repeat is done differently, so I just want you to be aware of that before you make your decision as to whether or not a violation.
And the second violation was because that first one was the advertising, and talking about a day, when I got that letter, I called that day to say, well, mine says monthly rentals, and she said, well, it says weekly, and then the next day, when I got in touch with her, I changed it.
Gotcha.
So it wasn't 2 days. The first day I tried to call, didn't get an answer back, and the next day I got an answer from her, and then I changed it that day. And basically, I don't appreciate people calling me liars, because when they looked at that, they said, you don't tell me you're renting all week, I see it there. And I try to explain, well, no, it's blocked.
Okay.
And you can't see that, which I understand
I
that.
get it. Mr. Rowley, if the board doesn't have any additional questions for Mr. Sorrell, if you would just have a seat and then let us kind of discuss as a board. I don't know how the board feels about it, but I think it's important to hear that if we do make this motion, it's for 2 days of a fine is what you're saying, is the time period.
Right, because in essence, by making this motion, if you find a violation, then you found that he has committed the violation for 2 days. Under a repeat, then your second part of your motion will be to determine if you want to fine and how much, knowing that it's up to $500 a day. But so it's important for you to just understand how these move a little differently.
Mm-hmm.
The up to means that is not a concrete amount. It's a limit, not.
It's a ceiling.
Right, it's just like the
Correct.
normal ones could be up to 250, repeats are double, so up to 500.
Should we make the first motion first?
My personal feeling towards the board is, it is a repeat, right? And the gentleman was in violation, went through the process through city to correct the violation, and then we did it again, right? So as much as I want to be compassionate and understanding and it's a mistake and you can block it, I think there probably should be some component put into this. I don't think $500 is the amount. I think that's probably a little excessive, but I think there probably needs to be something that's a statement of this is wrong and let's not do it going forward, if that makes sense. So whether that's, $100 a day, we're making $239 a day in a rental fee for however long it was rented. I think 2 days is reasonable. So I think for the board, it's coming up with what is that amount if there is one.
So you should make your first motion, and then you'll hear from the city as to what their recommendation is.
I move to find the respondent in violation of the code as referred to in the affidavit of this case.
I believe under the repeat, you have to acknowledge that it is a repeat
Yes.
violation.
I move to find the respondent was in violation of the code as referred to in the affidavit in this case and has committed a repeat violation.
I'll second that motion.
Motion is made and seconded. All in favor, aye.
Aye.
Opposed, nay. Okay, motion passes. City recommendation.
My recommendation for case 100-20, there's one violation, advertising an illegal short-term rental, requesting a fine of $500 per day for the following dates, May 19th and May 20th, 2020, totaling $1,000.
And that's the city's recommendation. It's up to the board to decide what you want to do. You can also hear from Mr. Sorelli regarding the fine.
Mr. Chairman, how much did he rent this place per day?
If I'm correct, it was $239 a night.
$239?
Yeah. So I can go back if you want to pictures.
I think it's 239.
I believe it was
I know where you're going with that.
239.
Okay, that sounds like a good number.
Okay, so what we would need is make sure we're on repeat violation and the second motion order.
You want to do it? What was your
I'll
amount?
go ahead. Yeah, I'll move to enter an order that a fine of $239 per day be imposed for the 2 days the repeat violation existed, for a total fine of $478 payable within 30 days.
Normally it's 30 days unless the individual needs more time.
Okay. 30 days, if fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Motion is made and seconded. All in favor?
Aye.
Opposed, nay. Motion carries. Thank you, Ms. Phillips. Mr. Sorelli, do you understand the motion that was made? You can step up.
Shouldn't it be just one day, considering I called the first day and the next day I did take it off?
The board ordered 2, city recommended 2.
And then I don't know what.
They were referencing $500 a day. I think the board granted some leniency
Yeah.
and got you better than 50% of what they wanted to take out of your checkbook. So what we can help you with at this point is if 30 days isn't enough time for you to make that payment, we can help you with that. Otherwise,
It's not the money, really. I mean, I appreciate reducing it. It's just that, it's just what's going on there. I
Yeah.
understand. I understand what's going on in the city of Clearwater, the short-term rentals. What I just don't understand, and it's nothing to do with anybody, is where you go into a beautiful neighborhood and you get an absentee owner who doesn't care about his house and rent it to undesirables, and the house looks terrible. There's no laws against that.
well, renting, as long as it's not a short-term rental.
Right, but you
Right.
go into a beautiful neighborhood, $600,000-$700,000 homes, and you get this home the shingles are falling off, it needs painted, there's 3 trucks in front of it, there's weeds, but
Yeah.
since he's renting it by the year, it's fine.
Well, if it's shingles are falling off and needs painted, he would go before the code board, and there'd be a
Well,
problem
then,
with that property, and
Yeah.
the city would go through the
Yeah,
same
but
process.
then I'll be in the same
they
spot
did with you.
where the people ratted on me. I don't want to be a person. I'm not like that, and
It's okay. Mr. Sorelli, I'm sorry that, you're going through that. Hopefully we learn going forward.
well, I know the rules now.
Don't-
I mean,
yeah,
I
don't
basically know
advertise
the
it.
rules. I never got a piece of paper saying this is the official rules, 31 days, and then when I go online, I see everybody else doing, even though you're right.
Yeah, I get it.
Right.
I'm sorry about that. And this is the only way that we start to curb that behavior.
Right.
We're live, citizens are here, they know it.
Right.
And as a board, in the city.
Do I have
and we
the
enforce
right
it.
to find out what person was?
I can't tell you on that process or procedure.
If it was anonymous, I doubt we don't have it.
Find out who it is anyway.
And no problem. Mr. Sorelli, I hope you have a good day.
Yeah.
And sorry about that.
So,
Safe trip back
How
home.
do I pay my fine?
You'll get an order in the mail.
Okay. Thanks.
Have a good day.
Thank you.
Moving on, case number 4.16, continued from 7/22/20. Case number 10220, fine respondent Ayad Elian at 1391 Gulf to Bay Boulevard in violation for code for door and windows, and issue an order with the compliance deadline and fine if compliance is not met. Is anyone here for case number 4.16? No? Okay, board, if we could have a first, please.
I'll move to find the respondent was in violation of the code as referred to in the affidavit in this case and has committed.
Just a regular purse, not a repeat on this one.
I move that to find the respondent was in violation of the code as referred to in the affidavit in this case, violation. That's not it either.
You're okay, you're getting it.
you're doing it. Yeah, that's good.
No,
Just keep turning them. There you go.
we're talking about the
Just a regular.
first
First
motion.
violation not
Yeah.
corrected.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
I second.
Motion is made first and seconded. All in favor, aye.
Aye.
Opposed, nay. Motion passes. Mr. Casman?
Good afternoon, Board. My name is Daniel Kazma. I'm a Code Enforcement Inspector for the City of Clearwater. This is for case number 102-20. It's 1391 Gulf Bay Boulevard. The issue was a violation for windows and door maintenance. Do you wish to see the pictures, or you just want me to do recommendations?
Oh, can you show us, do you mind showing us?
So there was one violation here for code section 3-102.c.1, C3, and C4 for door and window openings, window maintenance, and windows not facing the right-of-way. Notice of violation was sent on March 4th of 2020, compliance date of April 4th of 2020, and the certified mail receipt was received back on March 17th of 2020. This is the property in question, also known as 1383 Gulf to Bay, but it's on the, as you're driving down Cleveland Street where it splits in the Gulf to Bay and Cleveland. It's on the right corner. It's a strip store. It used to be a store right there, but they've boarded up all the windows and doors, and the property is pretty much abandoned. This was on February 22nd of 2020. I went back on March 4th of 2020, and all the windows and doors on that portion of the building are still boarded up and enclosed. Went back on April 6th after the compliance date, and they're still boarded up and closed. Over these past few months, no action has been taken to repair these windows or doors or remove any of this plywood. It's just not a state that a building is allowed to be in. This is on July 24th of 2020. Again, on November 4th of 2020, posted the property with the notice of hearing. They didn't respond to any certified mail for the notice of hearing. And went back on the 17th, and the property's still in the same condition.
Are any of the units?
Yeah, there's a temporary employee workplace right next to it, right? Is that the same owner? Is that one owner on that whole building?
It's the owner is the same for the entire building, but the individual units used to be rented out. It doesn't look like any activity is happening in any of the stores, but at that store in particular, they decided to just board up everything and just leave the property in that state.
And did you say a permit was pulled for that work or not?
You would not be allowed to just board up windows and doors. That's not
Yeah,
an
there was no
acceptable
permit.
state for a building to be in.
And there, it looks like there was portalets dropped off out there, like it's for construction workers to
There were
use.
some issues before with work being done on the interior, but that was a separate case being handled by the building department. There were stop work orders and work being done in the interior. But I don't know what the conclusion came of that. My specific concerns were just the exterior of the building.
Gotcha. I think this property's been before us for sign issues as well, if I'm, Janet, yeah. Any questions from
Any
the
other
board?
questions?
So that the property owner, he owns not only that corner, but also back behind there. And
The whole structure is several storefronts, and there's a little field along the road on the north side of the building too.
is this the whole structure twice as big as what's in violation? I mean, are we talking about half the structure?
It's pretty much half the structure's been boarded up. I've had to cut the property as well because they allow the grass to get overgrown in excess of a foot. But we have ways of taking care of that right now through the COVID emergency orders.
Are there running utilities in that building?
Not right now, no, I
No
don't
power,
believe so.
no water?
But that was just, at the time, there might have, when I first established the case, there might have been water going, but at this time, I don't believe there is.
And when you prior to that, you've had issues there and you've had them corrected, whether it be the weeds or whatever. Are we dealing with the same owner?
Yeah, the owner, Elliott Island is the owner of the entire property. It's a strip store with a small grassy area on the north side of it, north.
No, I'm sorry, south side of the property.
So he has corrected violations in the past?
No,
Well,
I had to have our contractor cut the property because they allowed the grass in the south side to grow into the street in excess of 4 inches and over a foot. This is just a separate issue with property maintenance of boarding up the windows and doors.
Are you having any communication with the owner?
No, I've attempted, I received the green card back, but no efforts have been made to make any improvements in the building or change the situation. And like I said, the other issue with the interior where work was being done, that was with the building department. I don't know many more details on that.
I believe I remember this building being here before. We had some issues with addresses or communication getting to him. He was here in person, if I remember correctly, and he was complaining something about how we were communicating with him wasn't getting to him because of mixed up addresses. I don't know if that was remedied or, do you recall that?
Inspector, did he actually receive the notice? You got it?
Yeah.
You said that you received the certified mail return receipt.
Yeah, it's directly
And it's-
addressed to Ed Elian, as it appears on the property appraiser website. That's the address that's given.
Yeah, it was some family, not important. Does the board have any questions for Mr. Kasman?
His recommendations.
You can give us your recommendations.
For this case, for 102-20, 1391 Gulf to Bay, for doors and windows, I'm requesting compliance on or before December 5th of 2020, or a fine of $150 per day per violation for each day the violations continue to exist. We're asking the board to authorize the following. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law.
And is that going to be $150 per the violation, or there was 3?
I'm sorry.
That fine, would that be that's per violation? Wasn't there 3 violations in the
It was just, those were supporting subsections of the code for window and door maintenance. The main violation is for window and door maintenance. Those are just supporting subsections. They're not separate violations in themselves.
Well, it's a commercial property. I would recommend higher. $250 a day.
Any other comments, or may I have a motion from the board?
I concur with the
Yeah.
amount.
Hold on one second. Compliance can be met for the doors and windows by removing all the plywood from the door and window openings in the property and just properly maintaining them as they are, either windows or doors.
Comments?
No, I agree.
Comments or a motion? It'll be the second motion.
I move to enter an order requiring the respondent to correct the violations on or before December 5th. If the respondent does not comply with that date, the board may order a fine of $250 per day per violation for each day the violation exists. If fines and fees remain unpaid for 3 months after such lien is filed, the city authorized foreclosure, collect, or settle such lien.
I second.
Motion is made and seconded. All in favor, say aye.
Aye.
Opposed, nay. Motion passes. Thank you, Mr. Kasman. Moving on, agenda item 4.17, continued from 7/22/20, case 103-20, fine respondent Salty LLC at 1401 Gulf to Bay Boulevard in violation for code for roof maintenance and business tax receipt, and issue an order with compliance deadline and fine if compliance is not met. Is there anyone here to speak to item 4.17? Okay, no. Board, we will need a first motion.
I move to find the respondent in violation of the code as referred to the affidavit in this case.
Motion is made and seconded. All in favor, aye.
Aye.
Opposed, nay. Motion passes. Mr. Kevin, welcome back.
Would you like me to go through the, good to be back. Would you like me to go through the entire case or just the recommendations on this one?
Typically, when nobody's present, it's assumed in violation, so you can just make that, and then he can present his recommendations.
Okay, perfect.
You board's good with that? Thank you.
Yes.
Yes, please.
All right, just the recommendations then?
And just to clarify, board, that's actually in the land development code, that when they are not here for the hearing, they admit the violation.
Can we see the pictures?
Okay.
Okay.
That looks like it's on the opposite
Yeah.
corner
It's
of the
the
building
very
we just
opposite
saw.
corner. So I won't go through all the violations. It's for business tax receipt required for the Conch Czar, which is a restaurant there, and roof maintenance. There's a massive hole in the roof, and the tarp has been placed on it, but no repairs have ever been done. Tarp cannot be a fix for roof damage. So this is the Conch Czar. This is in January 8th of 2020. You'd see the tarp on top of the roof. It has some graphics on the side of the place offering it, showing it as a Conch Czar. It's open at this time. This is a picture of our Acela program where I searched for a business tax receipt for the Conch Czar, and there was not one for it to operate as a restaurant.
It's open, you said?
Yeah, it was open, but they never obtained a business tax receipt to sell seafood at the location or run a restaurant. So this is the side of the property. This was February 10th of 2020. Again, tarps on the roof. Even the man who was the tenant in there, Leroy, who runs the Conch Czar, told us there's damage on the roof. I think there might have been also a building case on this one as well. Just a bare picture of the tarp. This is the posting of the affidavits for the violations. I did not get the green card from CLD LLC. They didn't sign for anything. So the property was posted on the 23rd of March. This is back in June. I went back to the property. The tarp is starting to deteriorate, and this was the sign left in the window. I don't know if you guys can read it, but it says temporary closed for COVID-19 renovations. So, this was just a review I got online for the Conch Czar.
4.5 stars.
Pretty good review.
Yeah, pretty good reviews, but it was operating a few months back. Just another picture on July 24th of the property. Again, another property I had to cut as well because they're not maintaining the grounds anymore. Again, November 4th, went back, tarp still on the roof. This is a notice of hearing posted on the door. They didn't sign for their certified mail for the hearing. Tarp is starting to really rip up. And then back on the 17th of this month, still no action's been taken at the property.
Mr. Kasman, are utilities on?
Not at this property, no.
There's no utilities on at all,
No.
power or water. Does the board have any additional questions, or we can have a motion?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
I second.
We already did a first, so his recommendation is December 5th,
Oh.
150 a
I have
day.
the same recommendation as the other property. This is a commercial property. It's been going on a long time. I think the fine should be $250.
Do you want me to say it out loud for you guys?
No, you're fine. You can make that motion if you have the second motion. Go ahead.
I move to enter an order requiring the respondent to correct the violations on or before December 5th of this year. If the respondent does not comply by that date, the board may order a fine of $250 per day per violation. For each day each violation continues to exist, if fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such a lien.
I'll second that.
Motion then made is seconded. All in favor, aye?
Aye.
Opposed, nay. Motion passes. Thank you, Mr. Kasman.
Yeah, the compliance can be met for the business tax receipt just by obtaining a business tax receipt in order to legally prepare and serve food, and compliance can be met for the roof maintenance by removing the tarp from the roof and repairing any damage that has occurred.
Thank you. Moving on, agenda item 4.21, continued from 7/22/20, case 10720. Find respondents Douglas E. Fisher at 10 North Aurora Avenue in violation of code for residential grass parking, roof maintenance, exterior storage, and vehicle repair, and issue an order with the compliance deadline and fine if compliance is not met. Is there anyone here to speak to item 4.21? Okay, if we may have a first, board.
1 second before you guys make an order. For the grass parking violation, that's no longer being attached to this case. That's going to be enforced with alternative means. The other 3 violations will go ahead, though, for vehicle repair, roof maintenance, and exterior storage.
So do we need to do a declaration for that, even though it's...
No, they're not asking for a declaration. They're going to handle it through an administrative process.
So we can just omit it from
Right.
the motion?
We'll actually just remove it. Just go ahead and make your motion, and we'll acknowledge that the city has removed that as a violation. So Nicole will have that.
So first motion.
Okay, so first motion.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
Motion is made and seconded. All in favor, aye.
Aye.
Opposed, nay. Motion passes. Mr. Casper?
Would you like me to go to recommendations, or would you like to see the pictures in this case?
Just recommendations are fine.
Recommendations.
Any preference, recommendations, recommendations?
Pictures are good for at least for this meeting for the board, so that they can get a feel for them the cases.
All right,
They're okay.
Fair enough.
show us the pictures.
There you go.
All right. Daniel Casman, Code Inspector for the City of Clearwater, Code Compliance. This is for 10 North Aurora Avenue, case number 107-20. Today, there's 3 violations of this property seeking through the board. Code Section 3-916C for vehicle repair in a residential zone. Code Section 3-1502 D1, D3, and D5 for roof maintenance, clean roof, false roof elements. And Code Section -1502.G1, G2, and G3 for exterior storage not for use outdoors, and construction material storage. Notices of violation were sent out on February 19th of 2020, February 20th of 2020, and March 20th of 2020 with compliance dates of March 5th of 2020, March 20th of 2020, and March 30th of 2020. And the affidavit of posting was posted to the property on March 20th of 2020.
Can I see the picture? Yeah.
What's that?
I don't see the violations, if you can point them out for me.
Oh, I'm
That
going to the
picture?
pictures right now, yeah.
He's going to go through those pictures for you.
This is the property in question. It's 10 North Aurora Avenue. I've gotten many complaints about the property, about repairs being done to the property, many vehicles in the yard, stuff being left outside, especially in the backyard. But this is just the front of the building. I've spoken with the owner many times about what cannot be done in a residential district, and he says he knows, but he's not going to stop. This is just a closer look at the front. This is in February 19th. Some tools on top of this vehicle over here. Some exterior storage, just buckets and random items, an office chair. He's got the hood off this car that he's working on at the property. This is a photo taken from the rear yard neighbor who gave me permission to come out of the property to take a look. This is again on February 19th. There's some fence panels and a bunch of cars he keeps in the backyard and a tarp on the back porch, which he's admitted to me there's a hole in the roof. That's why he had the tarp on it, but part of the complaint was from the tarp. There's also various items stored about the yard, strewn about the yard. Just random fence panels, and just a better picture of what's going on back here. I went back on March 1st, still has multiple vehicles parked in the yard, some items up front by the house, some tools. There's a cherry picker engine hoist he uses to do work on the vehicles. I came back on the 12th, he's doing work on the work van with the hood open. Multiple vehicles still parked in the yard. Here's his affidavits of posting on 3/20 of 2020.
And that is the owner?
Yeah, he's the owner of the property. Douglas Fisher is his name. I went back on April 6th. There was now a boat trailer parked in the yard as well. You can see, this is a picture taken from the street. You can see the vehicles parked behind the house. Went back on May 26th. He had one vehicle up on its wheels. He was repairing the wheels on a jack, and I created a post for the boat trailer. Came back on June 1st, and all that vehicle was gone, but now he's left his tools in the driveway. Went back to check the status of the backyard in June. Still vehicles parked in the backyard. More stuff has been added. I guess he couldn't finish with the work truck, so it was pushed out in the street. It doesn't have a license plate on it. I took some photos of it, and a few days later had to tow it because there was no license plate on the vehicle. The owner called me of the vehicle and said what was going on. I said I had to tow it, it was in the street, and he told me, well, I paid Mr. Fisher to work on my vehicle, why did he push it in the street? And I said, you'll have to talk to him about it. Went back again, second, there's another vehicle parked half in and half out of the garage with the hood open that he's working on. Went back, the vehicles are still in the backyard along with the exterior storage. Now he's got some tires and the cherry pickers in the back. Went back on the 16th of June, it looks like things had been starting to clean up over there. I had some conversations with him. Still were vehicles in the backyard, but he said he was working on it. He's added a few water coolers, some more tires. Went back on the 27th, but things were business as usual. Another vehicle half in, half out of the garage. He claims they're all friends' cars, and he's not receiving any payment for doing this work. Went back on, when was this, September 24th. Now there was even more vehicles. He was doing some minor repairs on them, just doing some fluid, it looks like. A bunch of tools were left out again. Came back on the 13th. He's now repairing a lawnmower that he claims is his. And he said the vehicle in the street had a legal tag. He was just working on it in the street. But he had all of his tools out again. At this time, I had gotten a call from 2 neighbors saying that at night he had 10 vehicles parked in the yard with a spotlight working on them during the various hours. They called the cops out for the noise complaint. I'm assuming that this lawnmower belongs to this gentleman who came by to have it repaired and possibly pick it up that day. This was on the 22nd of October. And again, still items being left outside. Went back on the 4th of November. Still vehicles parked in the grass improperly. Went back on the 10th, and he had another vehicle parked up. Those were his clients, waiting on the repairs being done to their car while they were there. And the situation in the backyard has not really changed much, with the exterior storage and the grass parking and the fence paneling. It looks like it's quiet a little bit down the front, but he still has issues with the rest of the property. Is anybody any questions?
Questions from the board, or we can make a second motion and we can have his recommendation and move forward with it if not. You can give me a recommendation.
For this property, 10 North Rory Avenue, case number 107-20 for roof maintenance, residential vehicle repair, and outdoor storage, I'm requesting compliance on or before December 5th, 2020, or a fine of $150 per day per violation for each day the violations continue to exist. Asking the board to authorize the following: after 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law. And for compliance for the roof maintenance, by removing the tarp from the roof and repairing any damages occurred. Compliance met for the vehicle repair by ceasing all commercial repair activities at the residence. Compliance met for the exterior storage by properly storing or removing all materials, tools, fence paneling, and any other miscellaneous items from the premises.
And I'm sorry, I missed it. And having the vehicles removed from the grass was in the previous.
The grass parking violation is being pursued with alternate enforcement. It's not part of this code case.
You said that earlier. Okay.
If there's no questions, we can have a second motion.
I move to enter an order requiring the respondent to correct the violations on or before December 12th of this year. December 5th. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day. Each violation continues to exist if fines and fees remain unpaid 3 months after such lien is filed. The city is authorized to foreclose, collect, or settle such lien.
I'll second that motion.
Motion is made and seconded. All in favor, aye.
Aye.
Opposed, nay. Motion passes. Mr. Kesman, thank you. I would think $450 a day may change the behavior.
Hopefully. I've explained to him if he wants to run a repair shop, he's got to go get a commercial location and go operate it out of there. It can't be done at the home.
Understandable. Moving on, case number 4.25, case 111-20, fine respondents James Rutherford at 2720 Morningside Drive in violation of code for exterior surfaces and issue an order with the compliance deadline and fine if compliance is not met. Is there anyone here to speak to case 4.25? Okay, if we can have it first.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Motion is made first and second. All in favor, aye.
Aye.
Opposed, nay. Motion passes. Ms. Ma'am, how are you?
Good afternoon. Shelby Brown, Code Inspector, City of Clearwater. Welcome, new members. It's good to see you all. Thanks in advance for your service. And Chairman, welcome back. Because it's good to see pictures, I'm going to start with the pictures first, just a few pictures, and then go to my recommendation. All right, since that'll probably be more helpful. So this is a single-family residential property. Okay, not going back. Bear with me a moment. All right, let's start there. Okay. This is a single-family residential property. We have property maintenance ordinances in the city of Clearwater, and this is for exterior surfaces. This picture was taken a few weeks ago. You can see that the paint is in pretty rough shape here. The property is supposed to be that tan color, and you can see that there's a lot of peeling paint that's torn away from the building. Let's see, there we go. There's a little bit more of a close-up, and these pictures are just representative of how the whole property looks. They have some kind of coating on there, and it's just in really poor shape. There's also some damage to the fascia and soffits there. This is a picture of the west side of the property, just so that you can see. So what we want to see here is one color of paint or things in good shape, no peeling, no mildew, no damage, and that's not what we have here. And then here's another picture of the front of the property. For what it's worth, I made my first visit to this property on November 22nd, 2019, and left a door hanger at that time. So when we're thinking about recommendations, which I'm going to make now for compliance by January 31st of 2021, I believe that's more than fair amount of time to get the property sorted out. So for case 111-20 for exterior surfaces, I'm requesting compliance on or before January 31st, 2021, or a fine of $150 per day for that one violation. And I'm asking the board to authorize the following: after 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law. And the way that they can meet compliance is to have any damaged or deteriorated structural and decorative elements repaired and or replaced in a workmanlike manner. This includes everything: the stucco, the trims, the soffits, the fascia, etc. Removal of all the mildew, the peeling paint specifically, and other loose materials. And then repaint all the affected areas so that it's accomplished to match the existing or adjacent surfaces. And then the building walls shall be maintained in a secure and attractive manner.
Have you had contact with the homeowner?
Yes, I have. We've had 4 phone conversations, the last one being yesterday. So we have been in touch, and I did post notices of violation as well as hearing notices at the property. I did speak with the owner yesterday. She said she'd made a little bit of progress. I went by, and it was the first progress I've seen in 12 months at the property in anticipation of today's hearing. And I'd expressed that it wasn't necessary for her to come, that we were going to give proper time for them to get it sorted out.
What was that progress?
They'd accomplished some more peeling back of that beige paint and gotten a little bit more white on the front of the property. It's, I'd say, 15% of where we need to be. So they've got time, they're moving in a direction, and she was just relieved to know that they were going to have more time to get it done with all the things that have been happening.
And it looks like you're giving her more than 60 days to get it done, so hopefully that 85% can be done in 60 days.
I think that we're being very fair. We know things happen, but we want the property to be brought up to the level of the neighborhood and into compliance, yeah.
Thank you. Any questions from the board, or we can have a second motion?
I move to enter an order requiring the respondent to correct the violations on or before January 31st, 2021. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation. For each day each violation continues to exist, if fines and fees remain unpaid 3 months after such a lien is filed, the city is authorized to foreclose, collect, or settle such a lien.
I'll second that.
Motion is made and seconded. All in favor, aye.
Aye.
Opposed, nay. Motion passes. Thank you, ma'am.
Very good, thank you.
Thank you. Moving on to agenda item 4.26, case 112-20. Fine respondents Yim Soo Song at 441 Palm Island in violation of code for short-term rental. Issue an order with the compliance deadline and fine if compliance is not met. Is there anyone here relative to case number 4.26?
They are not board, and this will also be a declaration of violation.
Beautiful, thank you. So we will need a declaration motion.
I move to find the respondent was in violation of the code as referred to the affidavit. In this case, the violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats violation, the board may order a fine of up to $500 for each day of the violation continues to exist.
Motion is made. Need a second?
Second.
And seconded. All in favor, aye.
Aye.
Opposed, nay. Motion passes. Thank you. Agenda item 4.27, case 11320, fine respondents Tololo M. Olasukanami at 109 Devon Drive in repeat violation of code for short-term rental, and issue an order that daily fine be imposed for each day that the repeat violation or violations have existed. Is there anyone here for case number 4.27? Okay, board, keep in mind that this is a repeat violation, so we'll need a first motion under repeat.
I move to find the respondent was in violation of the code as referred to in the affidavit in this case and has committed a repeat violation.
Second.
Go ahead, motion's made first and seconded. All in favor, aye.
Aye.
Opposed, nay. Yes,
And
ma'am.
as a repeat, we'll go ahead and present. Again, Julie Phillips, 109 Devon Drive for a repeat violation for case 113-20. There's one violation at this property, Code Section 1-104B for development code violation, and Code Section 3-919 for prima facie evidence of certain uses in residential zoning district. Property was posted with an affidavit posting and notice of repeat violation. A copy was also sent certified to the owner, and I did receive the certified mail back on August 20th, 2020. Section 802 for the definition of a residential use means a permanent place of residence for a family. A residential use located on residentially zoned property shall not include rentals for periods of less than 31 days or 1 calendar month, whichever is less, or which is advertised or held out to the public as a place rented for periods of less than 31 days or 1 calendar month, whichever is less. A residential use located on residentially zoned property shall not include interval ownership, a fractional ownership, or a time-sharing unit. Again, the definition of a repeat violation means a violation of a provision of a code by a person who has been previously found through a code enforcement board or any other quasi-judicial or judicial process to have violated, or who has admitted violating the same provision within 5 years prior to the violation, notwithstanding the violations occur at different locations. On January 24th, 2018, case 1318 was brought before the Municipal Code Enforcement Board and was found in violation for Section 1-104B for a development code violation and Section 3-919 for advertising an illegal short-term rental. The board ordered the respondent, who was present, to rent the property for at least 31 days or 1 calendar month, whichever is less, remove all daily and weekly rates, reviews, discounts, and update the calendar to reflect the 31-day or 1 calendar month requirement. The respondent was given until February 3rd, 2018 to comply, or a fine of $250 would be issued for each day the violation continued to exist. Compliance was met by the property owner. So I received another complaint on August 11th from anonymous neighbor, 2020, that this location was renting short-term. This is the front of the house located at 109 Devon Drive, and it's on the VRBO website, which was taken August 11th. The minimum stay, if you'll take your eyes to the yellow arrow, is 7 to 30 nights. When I tried to book the property for the 12th to the 26th, you'll see it says a minimum 14-night stay. And when I tried to book it, it went ahead and allowed me to. You listened to the previous case that was here. When you're able to set your time for 30 days on any website and you do it properly, it will not allow me to go ahead and book it for 5 days, 14 days, or 30 days. It's the setting you do with VRBO. You're in control of it. You're paying them a percentage. You're in charge of your website. This is the same day, August 11th, 2020, where I went ahead and posted it with the affidavit of repeat violation. There's a closer look. On the 12th, I went back to the VRBO website. Again, it's still listed for 7 to 30 nights. Again, I tried to book it from October 17th to the 31st for 14 nights, and it allowed me to do so. I went back on August 19th to VRBO. It still has 7 to 30 nights. That's pretty much just a different picture. 14 to 30 nights, and then the minimum stay varies. So that leaves options to when people are looking for a short-term rental. You might be able to stay a week, 2 weeks, a month. But here we had a 14-night minimum stay. Again, on November 9th, 2020, January 9th through the 23rd, 14 nights. It still allowed me to book the property. Again, on November 13th, VRBO, 14 to 30 nights. Again, on the 16th, same website, VRBO, 14 to 30 nights. It did allow me to book it at that time, and I'll let the board deliberate. Normally, when you deal with a repeat violation, just so the board's aware, during COVID-19, when you do a repeat violation, we would normally have pictures of every single day, and it seems kind of redundant, but that puts the burden on me to take pictures every single day. Because of COVID, you just kind of give people time and time again, so there could have been a much stricter fine, but there won't be at this time.
Does the board have any questions? Give us your recommendation.
Okay, so my recommendation for 109 Devon Drive, case 113-20, there's one illegal violation for the advertising of a short-term rental, requesting a fine the amount of $500 per day for the following dates, which would be August 11th, 12th, 19th, and November 9th, 13th, and 16th, 6 days at $500 per day, totaling $3,000.
I'll move to enter an order of a fine of $500 per day to be imposed for the 6 days of the repeat violation, existing a total fine of $3,000 payable within 30 days. Okay. If fines and fees remain unpaid for 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien. If the respondent repeats the violation, the board may order a fine up to $500 for each day the violation continues to exist.
Motion is made and seconded. All in favor, aye.
Aye.
Opposed, nay. Those ones are interesting to me because the max fine you're allowed to give them is $500 a day. But as we see on the website, they're charging $1,041 and change a night, to where they're still making over $500. So
Could be the cost of doing business if they want to make that change. At some point, the city can make a determination to go after injunctive action.
And that was my next question, like what incentivizes him to, or her, to stop doing that if they're still making over $500 a day and paying the fines? So there is a remedy for the city that doesn't just keep going that way. Wow, interesting. Thank you.
Thank you.
Moving on to case number 4.28, case 114-20, fine respondents trust number 152OCS Land Trust Services Corp. Trey at 1520 Clark Street in violation for code for exterior storage, and issue an order with the compliance deadline and fine if compliance is not met. Is anyone here for case number 4.28? Thank you, sir. If you please come up and state your name and address for the record. Were you sworn in at the beginning?
Yeah.
Thank you. So sorry for the long wait. Thank you for your
That's right.
patience.
My name's Donald Ingracia. Yes, I own the property, but the accusations are really against my tenant. So, INGRASSIA. So I'm really here, Donald, to get clarification from these two gentlemen on what my options are when my tenant doesn't comply.
Gotcha. So,
You know what I mean? So I don't understand why I should be punished.
Understandable. So the way the process worked, you would have to admit or deny that there's a violation to begin with, and then we'll proceed forward with getting you.
There isn't any more. We finally got to compliance. Complied, we got up to where it's all clear now. But I still want to know my options as to why, like how is it my fault that my tenant is leaving his debris?
I understand, and we'll give you time to explain that. So the board understands this isn't a declaration, is it?
No.
Okay, no problem.
Yesterday, since the last time I was there, there's still.
Daniel, if you could just.
Okay.
Podium.
Is it Donald?
Yeah.
Just have a seat right there, and we'll give you an opportunity to come up. Thank you.
Daniel Kasman, Code Enforcement Inspector for the City of Clearwater. This is for 1520 Clark Street, case number 114-20, and this is for. There's one violation of this property, and it was for exterior storage, code section 3-1502G1, G2, and G3. Did you hear him admit or deny, or?
Go forward.
We'll move forward as no,
Okay.
and we'll need a first and second eventually.
So, notice the violation was sent February 20th of 2020 with a compliance date of March 20th, 2020. Certified mail receipt was received on February 26th of 2020. This is the property in question. It's 1520 Clark Street. It was during a sweep in the Flagler Street area. It's right off of Flagler where Highland and Palmetto meet. If you were to continue to head north, you take the first right. into that neighborhood. What we're seeing here is a carport. It's full of a lot of furniture, buckets, construction materials. According to the code section, a carport cannot be used as storage. A carport's meant for cars, not construction materials or anything else. I went back on the 20th after having spoke with the tenant on the 12th about the items in the carport, and there was still the same situation. There were even a few more items added there. Some furniture. What's underneath that cover is actually an arcade machine. Old arcade machine, and just there's buckets, there's a door, there's just random pieces. I do not, the city doesn't mind the toys. Toys are not an issue. It's just everything else that's not really meant to be out in the elements and being hit by rain or anything. I went back on March 16th, and it's the same situation. The furniture's still there, a bunch of items that would be better stored inside, buckets, containers. At that time, we'd been hit with the COVID pandemic. I'd been in contact with Mr. Ingrassia about the situation, but he had explained to me several times, without the ability to evict, I have no power in any way to make my tenant stop with the exterior storage situation. He explained he was toothless to do anything about it. So I did little checkups here and there to see how the situation was. This was the first code board available to bring forward with this case. That's why it's being heard now. This was on the 1st of June. This was on the 17th of June, same situation, just tables, chairs, a bunch of stuff that doesn't belong outside being stored in the carport. This was again on the 29th of June. I went back on October 30th. Seems like some items were moved, but some other items were added. More construction materials. This is what it looks from the side. Again, not minding the toys really, but the other items don't really have any business being outside. I went back on the 17th to take a closer look. If you look here, some of the items have been left out in the street for garbage pickup, but there was still an amount inside that just didn't make sense. The buckets and all the arcade machines still, and just random construction materials. Here's a look from the side.
And we've had these cases before, and I think that it's an unfortunate situation that you're in when a tenant is not complying, and he's the one or she's the one living in that house or structure. There's only so much you can do as the owner to force them to comply. But what the board does is we can't find the tenant. It would only,
I know, so how is that
burden falls on you.
fair to me when I gotta pay a license fee? I'm legally allowed to rent the place.
Right.
But then either it costs me $500 to get rid of the tenant, or me and him fight all day. You know what I mean?
Yeah.
So it's been cleaned up finally, but I just want some kind of, why does it fall onto the property owner when I have to get a license for a tenant? You should deal that with the tenant. You tell me we're a business, but yet I can't go there and throw his stuff away because now I'm taking his stuff. I can't, either I evict him, which still costs me $500, or I throw away his stuff and get arrested. Or, I have no, my hands are tied unless I evict. I can't evict because you got COVID. Can't even really evict because of non-compliance anyway. It's not, he's paid up, so his rent's paid up, so I can't evict for non-payment, so what do you do? That's why I'm here for these two, because they're the lawyers.
No, absolutely, and that's a good question. Hopefully we'll get you some clarification.
The reason we go after the property owners, that's the only one you can be clients on, and that's the only one you can actually lien on the property. So, I obviously can't give you legal advice. This is my client, but the point is that you need to have a contract that allows you to enforce those particular violations, and the individual is responsible and or is evicted because of that. But it's clear under the law that if this board went after the tenant, we would have because we did this years ago, where we went after both the owner and the tenant. It was almost impossible to get proper notification to the tenants leave, to get them to comply, because they don't have to, because they don't own the property. What are you going to do to them?
Right.
So you have no power against the tenant. That's why we go after the property owner.
Understandable. And it's very interesting because normally this would be a bit of a different circumstance, but we're in a pandemic and there's rules and laws now against evicting tenants during this period of time, so, and that's an unidentified amount of time that we.
You know, we've discussed things many times and, you know, and we've come to understandings, but still, my hands are tied on what I could do.
Right.
But yet, he's not, because you can come here and say, yeah, no, he didn't come into compliance, and now you're fining me.
Right.
When I can't do anything.
Yeah, understandable. Mr. Ingracia, Daniel, did you need to?
Yeah, I have a recommendation page that
Okay.
maybe will help out with this.
They need to do the first.
We never did a.
Oh, I got pictures of showing that it's done.
Yeah.
And just so you know, if it's in compliance, then you'll meet the time periods if they.
Yeah, so then you would have no concern on that end anyways.
But you need to do the first motion.
Okay, so we'll need a first.
Okay, I move to find the respondent in violation of the code as referred to in the affidavit in this case.
I second.
Okay, motion is made and seconded. All in favor, aye.
Aye.
Opposed, nay. Okay, motion passes.
Again, Daniel Kasman, 1520 Clark Street for outdoor storage, exterior storage, requesting compliance on or before January 15th of 2021. Not 2020 where it says that, quite impossible. Or a fine of $150 per day per violation for each day the violations continue to exist. We're asking the board to authorize the following. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies under the law. And the covenant compliance for outdoor storage is by properly storing or removing all furniture, construction materials, or other miscellaneous items on the property not meant for outdoor use. So, January 15th, 2021.
Okay.
And you can step back up, Mr. Ingracia. And this is again, is a very different case because the times are in, but let's say that, you know, he is in compliance, you do declare that, but then in 3 weeks, we fall back to the same behavior that he has no control over. Are we then bringing him back as a repeat offender?
If the city so chooses.
Wow. Okay.
I mean, they can say he's in compliance, the affidavit of compliance would come to you for the next meeting. So once you make a determination that he's in compliance, accept the affidavit of compliance, that's the end of the case. If there's something new, that would be a new case. Unfortunately, that becomes a repeat violation in those scenarios. I mean, obviously, you know the circumstances about this one. So like when we talked earlier in the workshop, these are those kind of cases where,
right.
You know, you need to know the facts behind them to help you, should something happen in the future.
This is why I wanted to be here, so we can get,
Yeah, absolutely.
you know, all kinds of clarification, like what are my options? I mean, I'm being punished for somebody else's thing, and I can't even remove his stuff with a contract or not. I still can't touch his belongings.
Do you have any kind of agreement with the tenant at all?
Well, that's all in the leases that you can't keep outside storage, but if he doesn't get rid of it, I still can't go there and throw it away.
It's a problem. I mean,
You know,
you would evict him, but he can't do it.
you can't even evict, well, maybe now, you know, I don't even know if that's allowed now yet, but
I think you can.
I think you can.
you can evict now? But I'm just saying, you know, so this thing started back in January. I mean, I had no control.
Right. I think so that we can move on and you can move on. I thank you for coming. Unfortunately, he couldn't come with you to
Oh, he's right there, finally.
Okay. Can you?
Yeah,
do you
get him
mind?
up there.
Can you state your name and address for the record, please, sir?
Yes, my name is Gunnar Rivas, and I live on 1520 Clark Street.
Perfect. And were you sworn in when you?
I'm sorry, could you spell your name?
Gunnar.
G-U-N-N-E-R? G-U.
Rivas, R-I-V-A-S.
Thank you.
And were you sworn in when you first came?
Yes.
Okay, thank you. Do you understand the predicament that you're putting the homeowner in, that he's going to start being fined for you not keeping that clean?
Yeah.
And is that something that you can help him with so that we don't have to, as a board, we don't like issuing fines and fees like this when he's in a position where he can't handle it?
Yeah, what happened is a personal situation. I got separated, and most of that stuff was my ex belonging.
Gotcha.
So I tried to put him away, and then she called the cops. And then the cops told me, put him back in the house because she legally still lives in my house, but she's not with me. So it was a very tough situation.
Gotcha, okay. I think going forward, thank you for, if it is all cleaned up and the city will make that determination and judgment at some point, thank you for doing that. And hopefully, in respect to your homeowner, you can continue to keep it in that kind of shape and cleaned up to code.
Thank you.
Thank you. Mr. Kasman, did you have something else you wanted to add, or are you good? Okay. So we had a first already, so if we want to make a second, I think our recommendation was January 15th of 2021 at $150 a day, so that's up to the board's discretion on that end.
Well, I move to enter an order requiring the respondent to correct the violations on or before January 15th, 2021. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation. For each day each violation continues to exist. If fines and fees remain unpaid 3 months after such a lien is filed, the city is authorized to foreclose, collect, or settle such lien.
I'll second.
Motion is made and seconded. All in favor, aye.
Aye.
Those opposed, nay. Motion passes. Mr. Ingracia, do you understand the motion that was made and passed?
Yeah.
So although we set a deadline of January 15th and a fine of $150 a day, those fines and fees do not start accruing until said day, and apparently, the city will come out and determine that it's been resolved and that case will disappear and go away for the time being. We just hope it doesn't show up in here as a repeat offense, because then that fine goes from $150 up to what could be $500 a day, which is a big difference.
No, I understand that, but I still don't see how it's my fault.
Sir, you just need to come to the podium to address the board.
Yeah.
That's all, I just don't understand how it becomes my fault. He's an adult. You should go after him, he's the adult.
Yeah.
If he was a child, I can understand it's my fault. If it's my kid under 18. This is somebody else's stuff, somebody else's properties, but yet you want to come after the landlord, even though, we have a license to rent. I mean, I guess it just...
These
the property owner, that's the
I know, it's because it's the only one you can get. But it's not fair to the property owner. I mean, there's laws that should be changed. It shouldn't be the property owner's fault because a tenant doesn't want to comply to something.
So, is it Mr. Rebus? You mind coming up? May I ask?
Yeah,
I'm sorry,
absolutely.
I don't mean to get out of this,
Yeah,
but,
absolutely.
sir, and you were sworn under oath, and you understand what that means? It basically means that if you lie, you committed perjury.
Yes.
And that you could be prosecuted. So, would you allow the gentleman to come onto the property to just clean it up?
Yeah.
Okay. So, is it your testimony right now that by January 15, 2021, that property will be cleaned up? I'm sorry?
Yes, sir.
Okay. Thank you.
I do have to add one thing though. The guy does do construction. I mean, there's sometimes at night you want to, drop some things in the carport. I see these guys go back every day. I mean, he's not allowed anything in his carport but a car. I mean, it kind of seems a little ridiculous too that he can't put anything in the carport.
That seems to be what the city has said.
Yeah, I think normally it would be a storage shed or something in the...
Well, right.
Yeah.
What the code is, it explains carports are subject and beholden to the exterior storage clause, which is things that are not meant for outdoor use cannot be stored outdoors. Indoor furniture, wooden furniture is not meant to be outdoors. It's ruined by the elements. It's not meant to be out there. Tools, and it has to be properly inside. You wouldn't leave your tools out in the rain.
Well, it's not in there, it's a carport.
Even things left outside, it's not meant for that. Like I said, I don't mind the toys being outside, but just random construction material, that's all supposed to be stored properly indoors.
Right, one clarification.
Thank you, Mr. Kasman. Mr. Ingracia, thank you, and hopefully that clears it up. And if you have any additional questions regarding code and what can be there and what can't, please reach out to city staff.
Yeah, no, we're on good communications. That's
Perfect.
my hands were tied.
Thank you. Moving on, Agenda 5, unfinished business. It looks like 5.1 through 5.9. Is there anybody that's here to speak to 5.1 through 5.9?
It would be 5.1.1
Yep.
through 5.1.28.
Okay.
If there's anyone here.
Right, those are the affidavits of compliance, then we do the affidavit
affidavits of non-compliance separately.
Yes.
So what we're asking for is anyone involved in case 5.1.1 through 5.128?
Yes.
Yes.
Thank you. That would be
If
in.
there are none, you can do it as a motion to accept the affidavits of compliance.
Okay, so then the motion is regarding accepting the affidavits of compliance in
Okay.
cases listed in 5.1.1 through that 5.128.
I move to accept the affidavits of compliance as listed.
Second. Want to name them? Do you want to know?
Motion is made and seconded. All in favor, aye.
Aye.
Opposed, nay. Motion is passed. And then moving on to affidavits of non-compliance, that would be 5.4. Can we do these together if no one's here to speak to these?
nobody's here, yes.
Okay, so anyone here to speak to agenda item 5.4 through 5.9? Yes, sir?
5.9, Ross,
And there was another.
Okay. And Mr. English, was it?
Yeah, 5.6. We're kind of ahead of you there.
So those are the only two?
That's the only two?
So you can, the board can make a motion on the other ones, 5.7.
5.4.
Okay.
5.4.
So 5.4, 5.5, and
5.7.
that's it?
Right.
That we can make a motion to accept affidavits of non-compliance.
I'll make a motion to accept the affidavit of compliance,
Non-compliant.
of non-compliance.
For agenda item 5.
Oh, I'm sorry, for agenda item 5.4 and 5.5.
Correct. Do I have a second?
I second.
Okay, motion is made and seconded. All those in favor, aye.
Aye.
Opposed, nay. Okay, moving on. So the first one was agenda item 5.6, continued from 7/22/20, case 1820, accept the affidavit of noncompliance for respondents Gary English and Connie Martino at 3131 Downing Street for boat trailer storage.
That's you? And I think he's for 5.9. Did you
Yeah.
have that?
Yeah, we're gonna do 5.6, 5.7, and then 5.9. So you're third, sir.
How are you, board?
If Mr. English is here, do we need him to come up and,
Well, okay, so what we have here, in essence, is an affidavit of noncompliance, which the inspector has made a determination that the property is not in compliance as the day he inspected it. So you may want to hear from Mr. English as to why he believes the property is in compliance, since our inspector has already decided that it is not.
okay. Mr. English, can you step forward? Welcome back.
Oh,
Can
thank you.
Can you go ahead and tell us, as the board, why you feel that your property is in compliance?
Yes, because originally, when I was contacted by Ryan Odegaard, and I was out of compliance, he left me the items that were out of compliance. I moved the travel trailer, I moved the utility trailer, relocated another boat that I had, and fenced around the boat that's on the side of my house. Fenced or put carport siding, however you'd like to. We went over that before. And then I called him, and he came out to look at it and said, "You did good to go. You're in compliance."
Okay. Fair enough. Do you mind having a seat, Mr. English, and we'll let Mr. Odegaard come up and explain to us a little bit about the case?
Violation, it still is.
Afternoon, board.
Good afternoon.
Ryan Odegaard. This is 3131 Downing Street. This was actually from January of earlier this year. And it was brought before the board for, one was a declaration of violation, the other one was, a boat in the side or rear setback that was not screened by a fence, wall, or hedge. Notice of violation was sent out on 10/3 with a compliance date of 11/2, certified mail receipt. He refused to sign on 10/15. I got that back. I posted the property on November 5th and I put in an affidavit of noncompliance on March 26th. Just for your guys' understanding, Downing Street is located just north of Gulf to Bay and east of McMullen Booth. This was the property when I went out on 10-2. You can see he's got multiple vehicles on the grass, boats, RVs. Closer image of the RV here. And then you can see the boat that's in question. On 11-4, I went out again, no change to the property. This is when I posted it on the 5th. And again, just another image of the posting. This was on 11-19, still no change to the property. What he had done is the property to his west is county property, so he took all his vehicles and just put them on the vacant parcel that was in the county, besides the one boat that he still had on his property. January 21st, this was the day before code board, still no change. The boat's still not screened by a fence. At that time, that's when I brought him to code board on January 22nd. He was found in violation. I requested 30 days to come into compliance. Mr. Menino actually gave him 90 days, and it was explained to him the reason he got 90 days is because he had to pull a permit. And so when I went out to the property, he had erected a fence, but he did not did not pull a permit for it. And I explained to him when he asked me to come out, I said, yes, you did what we asked as far as screening the boat, but you didn't pull a permit. And the city code doesn't allow any fences above 4 feet in height to be forward of the structure. So he's not in compliance because the city would never allow that fence to be erected. So that's why I said he is not in compliance. And that's when he got upset with me, asked me to leave the property. He asked for my supervisor's name, and I gave him Ken Pieslak, and I have not spoken with him since then.
Okay. Fair enough. Any questions?
The board is aware, the order reads, move the boat to the side or rear setback, park it on an approved and permitted surface, and screen it by a 6-foot fence or hedge, or remove it from the property. Permits may be required. The compliance deadline was March 22nd, 2020. So what you have now before you is the affidavit of non-compliance because compliance was not met as of March 22nd, 2020. The fine, which is $150 a day, does not start until you accept the affidavit of non-compliance. So since March to now, there has been no fine, and nothing happens from a fine perspective until you accept an affidavit of non-compliance.
Gotcha. Yeah, these are
Yes.
interesting when it becomes two almost separate cases, right? I mean, because
Well,
on one hand,
and what happened is when I went out and he had erected the fence, that's when I put in the stop work order because he did not pull a permit, and that's how Mr. Cantrell picked up the case. Because, again, he was instructed by the board, you have to pull a permit in order to be in compliance. And when I went out there, I told him, because he said, look, I did it. And I said, yes, you did what I asked, but you didn't pull a permit. And again, the city would never approve a 6-foot fence being erected in front of the property.
Right. So as we gave him information earlier on the resolution side, the piece we left out was not knowing that this case was coming before us again, that it's not just a problem with the fence not having a permit. You also have a problem with the fence being 6 foot in the front and not 4 foot, in addition to not having the permit and the structure covering the boat.
Well,
correct?
and
So-
even if he put a 4-foot fence, our code states the boats have to be screened by a 6-foot fence. So he can't put a 4-foot fence and still meet the code that I initially had written it up for.
So in
Okay.
essence, he can't do what
He can't do what he wants to do.
Right, correct.
Okay.
Can I ask?
Yes, ma'am.
I'm a little bit confused and I guess this is a great example of, a lot of things happening simultaneously. So we already talked about something that pretty much sounded exactly like this at the beginning of the meeting, and now we're watching the same thing from a different inspector.
Well, the reason is
We didn't
because
have
I brought this case back in January of this year. So this case has been ongoing, and then Mr. Cantrell picked up the case for the stop work order in, I believe, March, is when he picked it up.
Right, and my point is, I wish, in the perfect world, this would have been presented together, because I think it would have affected our ruling, had I known that, you know what I'm saying?
I asked that question.
It's not, the continued, it's
So there's
being
two
shown
ways-
very segmented.
There's two ways of looking at that, and I
think in this case you are 100% right. Probably should have put them together for you to have knowledge of that. But normally we don't do that because we don't, you're supposed to take each factual basis separately. And so so you base your decision not on, we don't want to prejudice your decision by necessarily knowing some other violation has occurred for you to determine whether or not a violation exists in this particular situation. But I understand based on this, and some of it's also the fact that we have a new board, so we don't have a history on the property that's going on, but technically they are different violations. So the one that was back in January could have been corrected by doing a couple different things. He chose to correct it a different way, which apparently, as we sit here today, doesn't meet the criteria of the city. So that's what happens when somebody doesn't continue to talk to the city. They don't know, he decided what to do. It's not allowed the way he did it. The first one that I read, that's why I read you the order, is because they specifically told him what he could and couldn't do, which still required him to get permits, which he never did. So he was under the information after the first one, what he was supposed to do.
And I would argue that, and it's a fact that that violation that Inspector Cantrell brought earlier didn't exist at the time that Inspector Hosmer brought his case because the fence wasn't there. So by trying to correct this violation, the homeowner created a new violation for himself.
And we don't like to tell you, for example, there's a history here. It's not a repeat violation, so it's different. There's a history of somebody violating something, because we don't want you to say, okay, he's violated once, so he must have violated again.
No, I understand that, but when you're dealing with the same property, and it actually was a continuation of the same process, I think, for me personally,
And I think you're right.
I would have appreciated to have known both of them simultaneously.
Yeah, I think you're right, and I think we can make sure that doesn't happen again.
Just my opinion.
No, I think
No,
you're
and
right in
I
this
think it
one.
makes sense for continuity, because now we're gonna get a recommendation, and it wouldn't make sense for us to give a different date with a different complying when we've just given an issue. and-
No, and this one is, all you're doing here is determining whether or not he was in compliance as of March of 2020. If you determine that he was not, then the affidavit of non-compliance is accepted. The fine wouldn't start until tomorrow, technically. Yes, it does go back to that date.
Well, and that's my point, because we just gave him,
February.
or we just gave him, what, 60 days
I-
till February, I think, right? February 18th or something.
So I would have, you know what I'm saying?
Yeah, right. Interesting. Does the board have any additional questions?
Wait, one,
Yeah, February 18th.
That, let me ask you this, is that trailer on county property?
That's on county property.
And that's his trailer?
That is his RV, yes, sir. Any other questions?
No, I think we're waiting to find direction. Mr. English, you can step up for a second.
okay. I'm sorry, just want to correct something that I said so we're clear. What you're establishing today, if you accept the affidavit of noncompliance, that there was not in compliance as of March 20th. The fine would move forward after that date, I'm sorry. What I was trying to say is it's whatever date you accept the affidavit of noncompliance.
Right, and that's where we're saying, I think we're kind of having the same thing, is if we go ahead and we all agree that he's not in compliance, but if we go ahead and say as a board and make a rendering that he's not in compliance as of today, fines and fees start, but an hour and a half ago, we just gave the gentleman 60 additional days to correct.
That was a different
All
violation.
right, if I may, I'm sorry. So I think that would be entirely correct. We can do that, because this is really a two-phase process, and I look at it as like a criminal thing. You look at a guilt phase and you look at a sentencing phase. The guilt phase is, are you in violation? Yes, you are. We'll give you until March. Okay, if you're not in by March, then the sentencing phase is the fine. But to make this clearer and perhaps easier on the gentleman, what I would recommend is that the board simply continue this agenda item, where we're asking for fines, until the compliance date for
I think
the
we said
last case,
February
whatever it is, for
18th
60
is what
days.
we said, yeah.
If the gentleman comes into full compliance with both this order that we're under review and the order that you issued previously, what the city will do is withdraw the affidavit of noncompliance in this case, not ask for fines on anything. And then he will issue an affidavit of compliance on everything. He'll be in compliance, he has a 6-foot fence, it's permitted, whatever. However, if he is not in compliance, we're going to come back and we're going to ask for the fines, and in this case, we're going to ask for them retroactive to March of 2020, well, this year, which is what we would ask for today. Does that make sense? So we're essentially continuing this case. You're not going to issue any fine today. But if he doesn't come into compliance with everything that you gave him and with what you ordered him to do previously, then we start issuing fines. That's what.
Thank you.
So wait, so under that scenario, we would continue the affidavit of noncompliance until the March meeting?
February 18th was.
February, well, the meeting, February meeting.
Okay.
February, it's after the 18th? Probably the February meeting, if not the March meeting. And so you would hear it at that time. At that time, if he's not in compliance, the city's going to say, we want you to determine that there was no compliance as of March 2020. So you're talking about a year worth of fines that they're going to ask. You don't have to do anything today.
Right.
We're just going to go ahead and put it on that meeting. And we will hopefully remind you of what happened today, so you have it at that meeting.
Mr. English, are you understanding what's being said, sir?
Yes, but it is totally wrong. And I don't care how you look at this, it's wrong, because he was at my property after March and told me, first of all, he told me, if you build a fence around it, you know, it doesn't matter, move it back 5 feet, it's still out there, build a non-vision fence around it, and you'll be in compliance. Then I called him and asked him to come inspect it. He came out and told me, you're in compliance, you're good to go. Now, how can you go back and say I wasn't in compliance?
I think it's pretty clear. I read the order. The order, as far as the testimony the board's heard, I don't see how you've come in compliance. Permits may be required. You didn't obtain a permit.
Okay.
Okay, so you're not in compliance if you didn't obtain a permit. You could have just removed it from the property, you would have been in compliance.
It's a catch-22, okay.
Or you could, I mean, the order of this board at that date was telling you what you needed to do. This board doesn't give people permits. You have to go back to the city to get that. This board doesn't determine what exactly is necessary to obtain compliance. They're just telling you the time period to do it. So as of this order, it's certainly up to the board to decide, this order has not been complied with. That was back in January, almost a year ago.
Well, he came out after I completed the fence and said I was in compliance. How is that?
Mr.
English, that's not what I said.
Again,
Yes, it is.
No.
You call me a liar?
No, I'm not calling you a liar.
Okay, you ought not to, because that really irritates me.
I know, we keep doing the same thing, and that's why you asked me to leave your property, and I did, you spoke to my manager.
I didn't ask you to leave your property, you're lying again. No, you're lying.
Okay, this is comments to the board only, and it's up to the chair as to how.
When I went out to the property in March before his compliance date that you guys gave him, he asked me to come out and look at the property. I went out and looked at it, and I said, yes, you have screened in your boat. That is what we asked. And I told him, you did what we asked, but you did not pull a permit. That was part of it.
Yeah.
And his whole thing of, well, I don't need permits. He keeps going back and saying, I don't need them. I don't need them. You have to have a permit to erect a fence. That was it, plain and simple.
Fair enough.
I did tell him, you did what we asked. I also told him, you needed a permit. You're not in compliance because they would not allow the fence to be erected in front of the property.
Absolutely not.
Understood. Well, let me go ahead and nip that in the bud.
Permit was
Mr.
never
English.
part of this. I have the stuff that he outlined when he first contacted me. This was the rules of my compliance.
Well, sir, the only thing I would say to you is the city is giving you additional time. The board is giving you additional time, and the city's now recommending additional time into February for you to come in compliance.
I understand.
I can only tell you what, I'm the attorney for the board, not the city. So the board has looked at this, and they've acted under the earlier case. In fact, they're not acting at all under this case. They're gonna put it back on their calendar in February or March to hear it, so that you have to work with the city.
Understand. There's a permit required for a fence to be erected, is that correct?
I don't work for the city. so
Yeah, the city would have to tell you, and you're quite,
Where's the building department, the building department?
They're right here.
Well, I considered it, and I looked for a permit. Was there a permit required to put siding on a carport? No. I didn't find any category to put siding on your carport.
right.
That's why I didn't pull a permit.
I know,
I
Mr.
wasn't
English,
erecting a fence. I was putting siding on the carport.
well, I know, but Mr. English, I mean,
Carport's been there for 10 years.
you built a fence many feet out from the carport and around it. That's a fence to any normal eye, but I don't want you to get any more upset than you are. I totally understand your situation. I understand your frustrations, but as a board, what we need to do is we're gonna grant you some leniency. We're not fining you today. We're not doing anything other than postponing this very case that we spoke about till the February meeting, which gives you time when you come back in February to figure out with the building department on how you can rectify your situation. We want you to keep all your beautiful toys at your house, but you have to do it legally and up to code. And if it's fix the structure and the height of it, if it's get your permit for your fence, if it's change the front, you just have to figure out what the code is, communicate with them, and let's get it fixed. But I don't want to waste staff or any more citizens' time to keep going back and forth on what you were told or what you weren't told. But we are understanding of your situation, and I'm sorry for it.
I understand that
Thank-
you're coming out, that part was not carport siding.
That's okay. But I do thank you. So what we need as from the board is we're gonna just,
No motion.
no
No,
motion
we're
needed
just-
to push that.
no,
We're just
no
gonna push
action. We're just putting it on your agenda in
in February.
February.
Okay, so no action is being taken. Communicate with the city, just like we spoke of earlier. And we as a board wish you the best of luck on rectifying
I
this.
know that travel trailer keeps coming up, but that's a neighbor, it's an empty county lot, and I pay her every month, the owner of that property, keep that there.
I got you. You're good. We wish you the best, and you'll get it figured out, and hopefully, but here's the big thing, Mr. English, understand this part is, what the city said was, you kind of got yourself in this position when you made changes in what you thought was rectifying the situation, which put you in a bigger hole, right? So don't do that this time going forward, because if this case comes back before us from the city, they're gonna look for fines and fees to start when you originally violated in March, and that's where it's gonna get expensive, and there's not much we can do at that point, because they're giving you March, April, May, June, July, August, September, October, November, December, January, February. I mean,
Well,
we're now,
I don't look at it like that. I look at this as a new problem, which started right after I was told I was in compliance.
I get it, but my point is, don't just try to rectify it on what you think and believe or read in an older book. Make sure that you are 100% accurate on spending your time and money and rectifying it, and that it's permitted in what the city's telling you. Yes, you can absolutely do this, because we don't want to see you back in here. You wasted more time and more money, and then you're still not compliant.
Well,
And that's what brought us here.
I don't wish to
Yeah,
be back in there.
absolutely.
I thought everything was fine.
You're all good.
I was told everything was fine.
All good. We wish you the best going forward, Mr. English. Thank you. Moving on, case number 5.7, continued from 7/22/20. Case 5420, accept the affidavits of noncompliance for respondents Thessaloniki Kanatoas at 1938 North Betty Lane for permits. Is the gentleman for this case step up, please? Thank you. Were you sworn in, sir?
No.
Okay, if you'd be sworn in.
If you raise your right hand, do you swear or affirm to tell the truth throughout your entire testimony?
Yes.
Thank you.
Okay, and if you would please state your name and address for the record.
Rafael Sierra. Rafael, S like in Sam, IERO.
And do we want to hear from him why he believes, or is the city going to present?
It sounds like the city hasn't changed their position, right? No?
Inspector, he's not in compliance?
If I may?
Yes, sir.
We actually did submit a permit application And then, and because this is right after COVID started, since the last time we were here. And so we submitted the plans and the scope of work and the specs for the windows, because that's what they wanted on the application. And it was rejected by the online system, because then we had to separate it into 3 files. Resubmitted again, and then it rejected because it was not in compliance for something else. I called somebody in the city, not her, not Nilda, somebody else, and I just called a general number, and I never got an answer. And then things got really bad, and because of COVID-19, we're out of money, so we couldn't go and continue the process. But we're now almost back in shape. I'd like to extend that. We actually we're hoping to pull from all of the plumber, the AC person to come over here and pull their permit so we can get started and finish everything, even in the windows by January.
Okay, perfect.
So that's what we want to do.
And thank you for that. And I feel a bit of frustration because I've tried to do some things through the pandemic and not being able to get somebody or the online system. It is tricky and there are hangups with it. And so I
But our
understand.
goal is to complete by January, and if we can get until the February one to complete, actually the whole project, and have it completely inspected by that time.
Okay, perfect, thank you. If you would have a seat up front, we'll let Ms. Espinosa chat with us a little bit.
Okay, so I did an affidavit of non-compliance. Permit came in February. City requested some more information. As of today, there is no active permit. My affidavit of compliance, I believe, was done the end of May. The office, I was sent out the end of March. They had all of March to submit. Permitting people was still in the office. I came back in May, found no permit. That's why I did the affidavit of non-compliance. And it's still, and it doesn't have an active permit. It must have an active permit.
Understandable.
The initial deadline was March 27th, 2020 by the board.
I'll pull it up.
Does the board have any questions for Ms. Espinosa? I think this is, we're probably going to have these for a couple months. The fallout of issues during a pandemic, of how business as normal has changed for a city, but not just for how a city operates, but how citizens operate, and citizens understanding how to use the system and have success with the system doesn't always equate to the city's expectations, right, on how it should be handled.
Chairman, if I may, please. Permitting counter was in the office from the end of March all the way when I came back in May. So people were working in there, just the public was not allowed in the office.
And I totally agree with that, and I'm not blaming a system or communication on the city. I'm saying there's other fallouts for it. People lost their jobs, people's industries completely shut down, so pulling permits costs money, doing work costs money, and that's what I'm making that statement is on a compassionate side as a board, is we probably need to expect these situations to come up pretty frequently where you're 100% doing your job, and I'm not saying that anything was wrong, but I'm just identifying to the board that we are probably going to see these issues where, whether it's permitting issues, communication issues, or financial issues, that are going to be part of the equation moving forward. Does that make sense, Ms. Espinosa?
It is a discretion of the board. You can accept the affidavit of non-compliance. You can put it on a calendar down. It's whatever the board wants to do.
I don't know how the board feels. I think for me, can you step back up? Hearing the gentleman state that he's in a better position financially, and with the pandemic changing, and with the plans and hopes to move.
We want to finish this off because we're making payments on something that we can't.
Yeah, no, I get it, and you're incentivized there to do that, but when are you going to legally, rightfully, and pull a permit?
Well, like I said, we have a permit. I mean, that's what I was looking for right now, because I could prove that we submitted the permit request and also submitted stuff to the city. And so, but right now we're not going to take the time. But we can, and I know when I spoke with her last time, with that, I needed the individual subcontractors for the AC and for the plumber and for the
Okay.
windows. They also needed to pull their own permits.
So what you're asking us for, the board, is basically for more time. You need some more time to complete this.
No, to complete, well, those
process.
guys had to pull their own permits because they have a general contractor
Right.
permit already in, and then, but now we need this subcontractors for the individual mechanicals and stuff
Okay.
to be submitted. But we want to finish the project, the sooner the better.
Yeah, okay, thank you.
So your contractors got to get the subcontractors online,
To
right?
put in,
to-
yeah,
to
correct.
pull the permits that you.
Right, and we didn't want to do it for one, they had the issue of money, and the second one was because of COVID-19.
Right,
Since I'm the one who's watching them, I didn't want to risk myself.
right.
I like my health just the way it is, thank you.
Yeah, well, it's understandable. This might be another one in a situation where we're identifying as a board, you're not in compliance right now, and I think you're admitting that you're not in compliance, but I think where I seem to be leaning is to another one that we table until February, right, just like we did on the last one, that you just have to understand, again, like we told the last one, is when we grant this leniency, if the city comes back in our February meeting and we're still sitting in the same space that we are now, your fines and fees are going to be retroactive to that original date, and that's where we then can't help you on that side, if that
Right,
makes
no,
sense.
and I understand that, and like I said, our goal is to finish, and the sooner the better. So,
Okay.
but we want to finish the whole projects by February,
Well, I
the
think the
latest.
city would do the same thing we did last time, which was that we would we would ask to take no action in February. But if he comes back in February with the same story,
Right.
ask for fines.
We'll be finished by
Yeah,
then.
no, and is the board good with that?
I'm good with
Yes.
that.
Yes, I'm good, but like the attorney said, if you're not done
Oh,
by
we'll be
then,
done.
then we'll consider the fines.
It's going to be an incentive.
$1,000 a month for nothing
Yeah,
anymore.
no, we get it, okay. We'll
Gonna be an
We'll
incentive.
go ahead and table it and have February, best of luck. Just make sure you keep in touch with the city and be on the same page with communication and permits and getting your work done, and we wish you the best.
Thank you. I have a question for these two gentlemen, aside from this topic. For my personal house, I discovered, I tried to refinance, and they said that the city had a compliance liability. Now, the fines are 2.5 times what the price of the house is. Who do I talk to appeal that? You?
Call me.
You have your card?
Call me. Don't call me. Well, moving on, so case 5, Nicole, are you good if we move on while you do that? Moving on to case 5.9, case 1920, accept the affidavits of noncompliance for respondents Jeffrey Rothschild at 600 Edenville Avenue for parking lot surfaces. Is the gentleman still here for that case?
Yes, he is.
Okay. Would you please step forward, sir? And were you sworn in earlier in the meeting?
Yeah.
I affirmed, I'm a conservative Jew, so I don't swear, but I affirmed.
You're good, fine. Okay, can you state your name and address for the record, please?
Jeffrey Rothschild, 600 Edenville Avenue, Clearwater, Florida.
Okay, and Jeffrey, do you understand what we're doing today as far as why you're in noncompliance?
Yes, because it wasn't done in time. They told me that I should try to get it done by the beginning of the year, or March, or whatever it was.
Okay,
And I didn't do it, and I need more time, that's all.
gotcha, okay.
July 22nd, obtain a permit, repair the driveway to ensure that it's free from potholes, cracks, eaves, and maintain it on a regular basis. July 22nd, and $150 per day was what the
The
court
reason
ordered.
for that was basically COVID-19. I'm an Ashkenazim Jew, which puts me at very high risk. They've found 2 malignant tumors in my bladder. I can't lift more than 5 pounds.
Gotcha.
And I have uncontrolled diabetes. I just got out of the hospital. I actually mentioned to the lady, if I pass out, tell them that I'm diabetic, because my sugar when I got here at 1 o'clock was 540, and I'm supposed to go to the hospital if it's over 400.
Okay, well, relax and breathe for a minute. We don't want to lose you on
I
our watch,
also-
so catch your breath, and if you don't mind, sit in that chair right there so we can catch your breath and relax for a minute. Let's let the city come up and talk to us a little bit about the case and see if we can get you to,
All right.
but you're okay, just breathe and relax for us.
Good afternoon again, Board.
Ryan Odegaard, this is for case 1920, 600 Edenville Avenue. This was actually brought before the board on January 22nd of this year. And it was for one violation, code section 3-1502 K4 for parking lot and driveway surfaces. Notice of violation was sent out on 10/9 of 2019, compliance date 11/9 of 2019. I did get the certified mail returned unclaimed on 11/19. I posted the property on 11/13, and I issued the affidavit of noncompliance on July 22nd of this year. And just for reference, this property is just south of Gulf to Bay and west of US 19. This is the property when I first went out on 10/9, and here's the driveway. Just huge cracks, holes in it. It just needs repaired. The day before the code board, I went out and the property was the driveway was just busted up, and as you can see, it's just sitting there. So he started work without it, and I, again, issued a stop work order. When he went to the code board on the 22nd, you guys found him in violation. He was given 6 months, which takes us to the July 22nd date. This is when I went out to the property yesterday, 2 days ago, and you can see nothing's done with the property.
Any questions from the board?
So what is compliance? Is it
Compliance is
concrete, asphalt?
he needs to repair the driveway to ensure that it's free from potholes, cracks, heaves, and maintain it on a regular basis. The city doesn't allow, you can't just have a gravel driveway, you can't just throw mulch down, it has to be concrete, pavers, asphalt, and again, it needs to be permitted.
Right. And Inspector, did you say when the compliance date was?
The code board issued a compliance date of July 22nd of this year, 2020.
So he's 4 months out of compliance?
Yes, sir.
Any additional questions from the board?
No.
Do you want to step back up?
I did get a stop work order. All I did was tear up the driveway so I could replace
Yeah.
it. I actually bought 20 bags of concrete, and they actually have been damaged from the rain and the wind, so they've gotten hard, so I have to get more.
Yeah, I agree.
So I have to find something. I have,
But know that you have to have a permit. Okay, so before you go spend more time and money in lifting, 50-pound bags of concrete, you have to have a permit to begin that work, so.
yes, I was gonna get some help from some neighbors, but Dr. Andorfer, my next door neighbor, has sold his home and moved away. And I've gotten Carrie Miller, who's a social worker for Blue Cross My Insurance, and the Veterans Administration are right now trying to find a good solution for this. I'm a veteran with post-traumatic stress disorder, stress and anxiety disorder, panic disorder with agoraphobia. I felt real dizzy. I was trying to work on this.
Right.
And I went to the clinic on Druid and Belcher, and they thought I was about to have a stroke. And I was at Morton Plant for 5 days, and they said that I have what's called stress cardiomyopathy, which means that I'm so stressed out that my arteries can burst and I can die just like if I have a massive stroke. So I'm shaking now.
Okay, we don't want that, so just
I'm
relax.
trying to do my best.
You're
but
good. We want to try to find a way to help you, so.
I live on $892 for my Social Security.
Right.
And my mortgage is almost $600, and I have electric $100, water $100, and my phone $30, Doesn't leave me a lot of money to do a lot of stuff with, and that's why the social workers are trying to help me, trying to find something. Dr. Andorfer had suggested my next door neighbor, what he did was he cleared out the driveway like that, and he had a truckload of shelves put in. And I don't know if that's allowed now or not or what, but that's what he has in his house now.
Yeah, I don't think it's legal, but before you did anything like that, please make sure we.
But I'm trying to
contact
get
the
help.
city and find
I
out.
don't have money to call a concrete company and do that.
Right.
I'm almost 70. I look
No, I
older
get it.
probably, and I just, I don't know what to do.
Yeah.
I don't even know that I'll live that long, really, because I'm not doing well physically. But I'm trying,
Okay.
That's all I can do.
Yeah.
And I don't want to die living under a bridge somewhere. I've done a lot of work on that house, on the interior. I've got all new floors. I've got $20,000 worth of appliances in the kitchen alone, 2 French door refrigerators and an induction stove, a gas stove. I have beautiful floors, not just tile. I have really, really nice
Gotcha.
floors.
No, the house looks in great shape, and you know, although you did that work without a permit, the driveway does look better than it did, but
I just took the asphalt
it's
off.
still
and
not
then
in compliance.
But
So
I haven't been able to replace it.
do you see the ability in the near future to be able to get this done and complied?
I'm
However,
working with the social workers to see, Carrie Miller said there's an organization in St. Pete where they help veterans, especially wartime veterans like myself, and they do major construction projects to help them. And actually, this isn't as big a project as what they usually take on. So she's trying to help find something about that and seeing if there's another organization that can help me to fix that. So I can, because she's helping, she's for my medical insurance, but she's helping because my stress levels are so high.
yeah, no, understandable. And we want to help, and I know the city wants to help you as well. They're not in the business to just try to fine you in fees and make money on you, right? They just want it to be compliant, and that's their job. So I think working together with the city and with the board, we want to try to find a resolution for this to you, but your health is obviously most important to us. So let's not, you know, pass out or have any issues over the driveway. I would ask.
I mean, we were just discussing your options. You could do what you did with the previous cases. You can put it through some kind of, you know, review. We can look at the status of what's going on. I mean, at some point, obviously, the city's going to want some action taken, but if you want to look at this again in February, we can do that.
I've called concrete companies to try to get estimates, and they're going over 5,000 for that. I barely have $20 a week to live on.
No problem.
What I was just discussing with my client is that we could push this out instead of February, we would push it out to July. And what that means is that the gentleman would have been a year from when he would have had the compliance to be met originally. That's a lot of time now, and so in that time, he has to figure out what he wants to do, how he wants to do it. I know I can't tell him what to do, and I can't find the money for him, but, you know, that will give him 8 months from today, and a total of 12 months to figure out what to do, and I think that should be enough time. So instead of going to February, well, actually, we would just continue this thing all the way to July. As long as, and especially, because it looks like it's maintained
Yeah, and that's what I was going to say. That seems real reasonable.
but I will say, if it falls out of what maintenance as it looks now, or it doesn't get any better, they're gonna come back.
Yeah, right.
Inspectors are gonna come back.
If safety is an issue, right?
But
Cracking.
And that's what I was going to say. It possibly looked unsafe before, and even a mailman walking up your driveway breaks an ankle. But I think at this point, I don't think we're questioning the safety of it. We're just, right? We're not questioning the safety of it. We're just questioning that it's not in compliance, which it's not. So I appreciate the city, and I'm sure you do as well, giving you the leniency of, 8 to 12 months, giving you eight calendar months to hopefully find the channel and the resources to get this done. I wish I could, personally come help you mix concrete and stuff. I don't know if I'm allowed, but
I'm trying my best. I really am. I mow my lawn. I have to take a chair, and I mow a little, and then I sit, and I mow a little, and then I sit, because I can't stand long enough to
we
mow
get
the
it.
whole lawn.
You're fine. Let's pull this off your plate for now. Let's let you
We'll put it on the July
relax.
agenda.
We'll put it on the July agenda. Hopefully, you stay healthy and safe, and let's figure a way through resources and channels to get it done. But just know that there is a deadline, and when we do hit that, the city has to do their job. And I would hate for you to all of a sudden see those additional fees because it's not obviously a cheap repair to begin with.
Yeah.
Is that fair enough?
I hate to lose my home, yes.
Yeah, we don't want you to do that as well. So stay safe, and thank you so much for coming in, all right?
Thank you.
Don't forget your briefcase.
Moving on, agenda item 6, other board actions. 6.1, cases 6816, 5919, 23419. Consider request by petitioners Mohammed Faour at 839 Lantana Avenue and 763 Mandalay Ave to reduce the fine regarding short-term rentals, and if approved, issue an order that specifies the fine that it includes administrative costs and establishes a date payable or the lien will revert to its original amount. Is anybody here regarding agenda item 6.1? Please step forward. Thank you so much for your patience, and sorry you had to wait the long haul. Were you here to be sworn in?
Yes, I was.
Okay, perfect. Can you state your name and address for the record, please?
Jenna Fowler, 1021 Warrior Drive, Murfreesboro, Tennessee.
And how are you,
Faour.
and how are you related to Muhammad?
He's my husband.
He is your husband.
And I have tried in a short period of time to become privy to all of this, so bear with me. She's probably going to make me more privy to all of this after her presentation. But best I understand, on 763 Mandalay, there was a long-term, this was after the short-term rentals in North Beach were not a thing. So there was a long-term renter from New York in Mandalay, and he was subleasing on Airbnb. The only reason that my husband ended up finding out is because we got a buyer for the house, and there was a lien on it when they pulled it. The 839 Lantana, that's actually the house that we reside in when we come here, and that one, we were leasing it, or short-term rentals, and then when we found out it was, that you couldn't do it, it wasn't allowed, they completely shut it down. Best to my knowledge, that's what I was,
Okay, no
what I was
problem.
told, yep.
If you don't mind, have a seat in that.
And really quick, I do also have 2 sales contracts, one on each of these addresses for today.
Current sales contracts?
Yes,
Okay.
closing in like 6 days.
Okay.
Okay,
And excuse me, ma'am, how much are they under contract for?
do you wanna look at them?
Yeah, you could just read them.
Okay, let's see, the 839 has sold for $595, and the 763 has sold for $450.
And how much outside of the city do you owe, or your husband owe, on those 2 properties?
I think 839, I think between both of them, it was like $40,000.
How much?
40,000.
You owe 40 grand?
I could be wrong, that is what.
Are you talking about the fines, or are you
I'm
talking,
talking
are you
about
asking
the
about the
fines.
fines?
Can I also say something else? Sorry, I'm like really flustered. So also at 763, I do believe the reason that the fines are so enormous is because the guy that was there was receiving the mail and disregarding it completely. We reside in Tennessee and didn't get the mail. I was told that a piece of mail did come to my husband's clinic, which is also in Tennessee. Our business manager that ran the clinic then left MIA. I'm not saying that is the reason why it wasn't found, but we would have never allowed a year. We had a lease with the guy for a year. We would have never allowed him to sublease, you know?
Okay, no problem.
Okay.
Have a seat right here. I remember, I think your husband was in here with us, and he was a doctor from Tennessee. I recall him coming in.
We do have, the total for the 3 is $54,500,
What's 3?
the 3 properties.
I only have 2 properties listed here.
I'll explain.
Okay.
So this is probably one of my favorite short-term rentals, Julie Phillips. I'm sorry, short-term rental inspector for the city of Clearwater. Muhammad has been renting his properties since 2014. I still have this from Airbnb. I did not think I was going to need to present for fines. I have 91 inspections I've done on their properties in about a 5-year time span. I have brought 5 cases to the board for Muhammad. Each one of them was found in violation where he did not show. Where they have each one of their properties listed, which was 839, 843, 763, and if I'm not mistaken, the first one was 937, Bruce, that you own, but I think you sold. That was the very first one that came to code board. And each time Muhammad did not show, he corresponded with Nicole. He, said he was going to come. He didn't come. He wanted to push it to the next date. He still didn't come. The very last time somebody showed was at 763 Mandalay, and he had an attorney present, but he was still found in violation. So we'll start with the first one, 839 Lantana. The first case that came was case number 6816. He was found in violation for $3,000. And then another one came, excuse me, and I can give you the dates. The first one, that was a repeat violation, was May 24th, 2016. That was for 839 Lantana Avenue. They were found in violation for 6 days for the advertising, and that was $3,000. The second one that came was 6916, which is 843 Lantana, and that's the house next door. So because he was found in violation originally from 937, he also owned these properties, making it a repeat violation for every property you own that you're violating in Clearwater. If you read the definition of the repeat, that's why I continually read it at the hearing. He was in violation for 12 days then for $6,000. Again, 839 Lantana became before the board, case 5919 on April 24th, 2019. And at that time, he was in violation for 63 days for $31,500. At that time, there was a gentleman named Ken there. I can't think of his wife's name, but she did come to the board at that time, and when I started to present, she got nervous and she left. I'm not sure if you were here for that time. But then again, on case 23419 on November 21st, 2019, that was 763 Mandalay. There was also somebody renting, and they were also found in violation for 28 days for $14,000. So, and I don't mean any disrespect, they know the code. Each time I bring somebody before the board, you have to send another notice of violation. Residential area, 31 days, 1 calendar month. You're in charge of your websites, every single structure that you have. So I'm just not really feeling that lenient. The people that live there full-time, that pay taxes, have to tolerate different people in that house all the time. I have a list, I was trying to look through it and find it, but there is records from the police department every time people have to come out for either beer cans, noises, yelling. It's just not fair to the community. So I understand that he's selling them and they want a reduction. I just don't think it's fair for violating from 2014 to 2020 what it does to the neighbors just because you feel like selling them. And that's my position on it.
So,
Can I ask a question? So you said Ken was in court. I'm just trying to figure out why he would be here if he was just the tenant.
Because your husband said that he was living there with this female in the back.
Okay, so living there as the tenant, but he was called to court?
Julie, I'm sorry, I just need you at the microphone.
well, I'm sure we didn't,
That's just something she needs to talk to her husband about. I can pull my case summary if you want me to go date by date.
I guess I'm just
certainly do
thinking,
that.
I'm thinking back to the case, I mean, all of these have been very interesting, I got to listen to all of them, about the tenant not being responsible, so why was Ken in court? He was the one that was renting for the year that subleased it to Airbnb.
Ken was never in court. This is a municipal code enforcement board,
Okay.
which they came, and Ken's either spouse, girlfriend, wife, I'm not quite sure how she was related to Ken, came here to speak on Ken's behalf and Muhammad's behalf, and when I started to present, she got up in the meeting and exited. If the board wants to look, or if I'm allowed to give this to Muhammad's wife, I'm happy to do so. It's every inspection I've done at 839 Lantana since July 2014.
So did his wife, girlfriend, et cetera, did she present about the violation of subleasing to Airbnb for a year?
As I stated, when I started to present, she left.
Okay, so but what were they originally here for?
Because Muhammad, your husband, asked her to come and explain what they were doing.
Which-
Which, I mean, you have to, it's all hearsay, you have to speak to your husband about that as an
I'm
investigator.
just
I can
wondering.
only,
Yeah, no, I'm
say
trying
what
to
I've done.
understand it as well. I'm just wondering, because there is, you know, a very well-written agenda. So what would their agenda have been to
let
be
me,
here?
let me just explain something to you. The
Yeah.
board doesn't hear from somebody unless they have a written representation that we can verify, and Mike always asks to make sure that they have the ability to speak on behalf of the person. So if they spoke, which doesn't sound like they did, but if they did speak, or if anybody speaks, we have written authorization, otherwise the board wouldn't hear it. So that, I mean, it sounds like from Inspector Phillips that no one spoke, so it's kind of irrelevant. But whoever y'all, if you give somebody written authority, then they can speak. If you don't, they don't.
Okay.
But it's kind of irrelevant to the point, which is, Currently, there are $54,500 worth of fines. The administrative costs are $5,450.80. You'll always hear 80 cents, so don't be surprised. And this board has a discretion to do anything or nothing between those two numbers.
Yeah, and I remember these cases from the past, and I think citizens of the neighborhoods actually showed up on some of these and sat in the back and complained at some of the issues and not being able to sleep, not feeling safe, and I think there was multiple of them. The board has that ability to make that decision. I think, it's great to hear that there's a contract on it, on each of them.
Yeah.
It's great to hear that you only owe $40,000 on them and you're making, selling them for, close to over $1 million. So I think there needs to be, this has been a lot of time and energy on staff's resources as well as the impact it's done on the neighborhood. So I definitely think there is some fee that should be paid in the closure of this. I don't think that administrative cost is enough. I don't know how the board feels if, the entire amount of $54,500 is, a direction you want to go. But is there any discussion on, where we think that happy medium is?
The one thing I don't know if you picked up that Inspector Phillips was telling you, but you do know that each one of these fines were $500 per day.
Right.
They were repeat violations.
Right.
And-
Well, and when we hear that it's not since yesterday, I think we identified 2014, so it's been going on for quite a while.
And the only point I would bring up as you make your deliberation, board, is to recall back to the prior case that you had where you said, well, we had a $500 fine, but the guy's renting it out for $1,000. And your lawyer says, well, that's the cost of doing business. Well, it sounds from what I'm hearing from the gentle lady, which is why I asked her, that she has substantial equity in the property. So they made money by breaking the law, and now they're going to make a lot more money if you go down to administrative costs or anything. There's nothing that I'm hearing that's saying these fines are stopping the closing from taking place. There is more than enough money to allow the closing to take place to pay off everybody, and they'll still walk away with money. So I think that's why, and I don't want to speak for the inspector, but I think that's why she's saying, I would say that's what city would not support a lien reduction.
So if we didn't make money on the houses, you wouldn't have said that?
I'm sorry?
If we weren't making money off of the houses that sold, you wouldn't have that outlook on it? Because that's all I heard, was there's more than enough money to give back.
Well, let me ask you this, ma'am. Is there enough money from the closing to pay the city and to close on the property?
There is. The problem is that the renter that was there for a year is a big chunk of what we owe that was subleasing, and we had no idea until we got a buyer for the house.
I don't understand what you mean. You're selling for $1 million, you owe 40 and 50, so you walk away with $840,000 in cash. Well, I'll give you $100,000 in closing costs. You're gonna walk away with $700,000, right? And you broke the law, right?
Right. So how much money is owed from the renter that was subleasing illegally, that was renting from us for a year?
What's the address?
Property is it in?
It's at 763.
14,000.
That was completely not known about 100% until we got a buyer for the house.
I just keep getting, one of the things that always sticks out to me is, this has been going on for, 7 years? I'm a landlord as well and a tenant. I see both sides. But you've definitely prospered at the cost of the neighborhood's, feelings and feelings of safety and all that. I was also very happy that you asked about the sale because I didn't want to impede that. I didn't want to be responsible for that. But with making close to $700,000, we have to at some point send the message that you can't just keep ignoring the law and then part of doing business and you still make out, right? So,
I don't think this is any justice, maybe it's speaking too much, but we are building a home in Clearwater, and every single dime that we get from all of these houses selling is going directly to that.
I don't see the connection.
Okay, I'm just saying.
I'm just thinking about all the neighbors that have felt, and have complained for years, and like I said, I'm a property owner and I rent as well, but that's 7 years of ignoring the law or the fines and the conversations, and I don't know. What do you think?
So what is to be said about the mail coming to the guy at 763 and him disregarding it and us not knowing about that till the house was purchased?
If I can answer that for you. I've had multiple conversations with Mohammed, and it's actually the owner's responsibility to get with property appraiser. Each time I've sent him mail, it came back. When the clerk would send him mail, it would come back there in, I think it's Shelbyville, Tennessee, but you have to register your properties properly with property appraiser. They can't go search you out everywhere. And I've had that conversation with him every time we've gone to the board, and he asked me how it went.
We also sent notices to their attorney, Clearwater, on each one of these orders.
Is that Elizabeth?
No, James.
Lampard, I guess.
Yep. So, and somebody signed for at least one of these, the $14,000 one in Shelbyville.
Yeah, so they signed for the notice of hearing and
The notice of the hearing and the order. So, I mean, things were sent out.
I mean, even your concern of the 14,000, I mean, okay, so to answer what he said, if you owed what you're making, what you're closing on, and it impeded the sale of the properties, we would be a little more hesitant. It's not about, oh, you're making money, we want to slap your wrist. It's like, our decision isn't impeding the closing for the next family moving in or your family. Even if you were to subtract your $14,000 for the one property that we didn't know, you're still sitting at a fine of over $40,500. So we're still at a pretty good sized chunk of change. It's probably best for us as a board to make a decision on what is that fine. Do you stay at that 54.5, or is there additional leniency that?
I'll make a motion.
Wait. Because we have a new board, I just wanted to check one thing. Okay. Well, we don't want, we have a new board, but just so you know, generally, your rule is not to reduce a repeat fine.
A precedent, you're saying, that's been set by this board is if
It's
it's a
a
repeat?
rule that a previous board has adopted.
Gotcha.
You have the discretion to do whatever you want.
Right.
But again, because we have a new board, I need to tell you things that prior boards have done.
Right. Which page here are we going to use?
So there's the reduce lien, the administrative cost, or the exceed side, but where is the language if there is no change to the amount?
You would just make a motion to deny the request.
Okay, I'll make that motion to deny the request.
I'll second that.
Motion is made and seconded. All in favor, aye.
Aye.
Opposed, nay. Motion passes.
Can you tell me what the total is again, please?
54,500. Is that correct? No change?
That's exactly correct.
Thank you.
Thank you. Agenda item 7, nuisance abatement lien filings. Nothing there?
No.
Wow, this board made it through the first one back, and thank you, City, for, putting it back on and putting on your show as always. You always do a wonderful job, and look forward to hopefully next month and getting through. Hope everyone stays safe, but it's nice to see everybody again. Thank you. Meeting's adjourned.
Thank you.